They feel like with RaDonda's verdict set a precedent for them to be considered criminals should they ever make a mistake. Now, more speakers are expected this morning, so that's what we are waiting for. We'll, of course, bring you much more coverage later on. Holly?
So there you have it. We are live today. I just wanted to pop in here and screen for you the RaDonda Vaught sentencing. As you know, in nursing, this is super important. We're all looking to see what's going to happen today. So I have found a couple of places. I think I have a stream that we can actually pop into. So I will do that in a minute. But in the meantime, I'm just going to continue to pop back and forth and show you some of the things that are going on right now. Some of the live looks from the Capitol in Tennessee, which is in Davidson County, Nashville, Tennessee. I will go ahead and show you some of this. If you don't know what's going on, there is a nurse named RaDonda Vaught who was who was convicted of criminally negligent homicide, and she was convicted. Basically, she had a medication error, and she went through the entire process. Actually, the board reviewed this case. This from several years ago. The board of nursing reviewed the case. She did not lose her license initially. She did seek employment elsewhere, and through a series of events, the hospital that she was working at was Vanderbilt University Medical Center, that's in Nashville, Tennessee. Ended up getting had some questions and were audited by the Medicare system, and because of that, this came back up. And when it did, she went back to the Board of Nursing, who then opted to remove her license. So she lost her license. She at all times has claimed that this was indeed her fault. A patient did die. She has said that she did commit a medication error, but she owned up to it. She did all the things that they tell us to do as nurses. So, yeah. So here we are. That led to today. So she was actually found criminally negligent, and that is the large hurdle to cross, and able to in order to actually have that conviction. The problem that we have, though, now that this conviction has happened, is that nurses are scared. Nurses are already leaving the profession left and right, and now nurses are terrified. What happens if I give a Tylenol instead of an aspirin and a patient dies 5 days later? And I know that that's a generalization, and of course, this case is much different if you know the facts of the case, but the implication is still there. So let me pop back over into what's going on here. Let me see if I can share my screen. I found a feed coming from Nashville that's on Twitter. Let me see if I can find that and show it to you. And you can see what is actually going on there. Okay, so you can see, I'm just going to scroll through here a little bit. You can see that the people are already lining up outside of the courtroom. People were allowed to get there as early as 8:30 and start sitting. It was first come, first served basis. There's only so many people that can be there. So there are already is a line. Coverage is supposed to start in about 20 minutes or so from now. So we will see what's going on with that. Moving down, you can see there's another tweet of all the people outside of the courtroom right now. And look at all of the support outside. So if you've never been to Nashville or never seen the way this is set up, the courthouse has a really large, one of those large staircases in front of it. And then on the just opposite that, there's a large park area. So that's what you're seeing right here. And this entire thing looks to me to be completely filled with nurses. So I'm really curious to see how many nurses are actually there. There's, you can see there's all kinds of nurses. So there's a sign back here. I don't know if I can make this bigger so you can see it. See this sign back here? It says, "We are nurses, not criminals." Right? So I really like that. But and there are a lot of signs like this one. It's heartbreaking right now what's going on in our profession. And so I'm really hopeful that this sentence today is something that does not cause a further division in nursing in the public. Um, but I digress. Okay, let's keep looking. So there are a couple of other things I wanted to show you here. There are a lot of people there. You can see a lot of purple. And if you want to know what the purple is, it's RaDonda's favorite color. So that's kind of where the purple thing got started and why you'll see so many people in purple right now. Here are some other signs that I found really fascinating. Let me see if I can pop these up. And I don't know if you can read these. I don't know if they're large enough for you to see, but they say nurse go to work, now go to jail. Heroes to zeros. I've seen that one quite a bit. Seeking justice for nurses and patients in a broken system. And I like this sentiment because that's exactly right. Did RaDonda make an error? Absolutely. And she owns that. But did the system make an error? Absolutely. There was lots of system failures that happened here. So just to squarely place the onus on one individual for the outcome, this horrific outcome of a patient death, which is just the worst thing that could happen as a healthcare provider, as a nurse, to have someone die that was in your care. This sentiment to me really sums it up. It's something that I think that we should think about as we're moving forward. This is a good one. We're nurses, not criminals. Again, I've seen that one quite a bit. Just going through to see some of these tweets. This is interesting. I don't know if you can hear it. If you can hear this, pop me a comment down in the comments section and I will drop it up on the screen. Or if you have comments at all, just drop them in and I will put them up and we can talk about them. We can talk that way. So this, I don't know if you can hear this or not, but this is one of RaDonda's friends that is there with her, and she's talking about it. You can go watch the live feed if you want to. It's on Twitter right now. WSMV out of Nashville is actually broadcasting this, but they are showing the people that are having the rally out on the lawn for RaDonda. And there are several people there. Judging from this, it looks like hundreds of people, which I think is amazing. Hundreds of people are there watching, trying to wait and support RaDonda. You see all of the shirts that they're wearing. You see the sea of purple, which is RaDonda's favorite color. And she's talking about right now how all of these, now I don't know if you can hear it, so I'm just like relaying what she's saying, but she's saying that RaDonda has seen all of the support and is super excited about the support she's received. So thankful and grateful, and she's telling everybody to make their voices heard, be loud, so that everyone inside can hear them and hear what's going on and know that they're there to support them. I wish I could have been in Nashville today to support her, but life happens. So that's why I'm trying to stream this to bring it to you. And just in full disclosure, I actually went to Vanderbilt. I graduated from there with my master's in nursing in 2005 and my doctorate in nursing in 2010. And just so that everyone knows, because I don't want there to ever come back and say there was any bias, there was... I absolutely did not have any type of experience that was like this. I can say that the university and the medical center are completely and totally separate. They are not the same, which is good. Oh, you see them rallying now. They're chanting RaDonda, which is amazing. Anyway, there is no affiliation between the two. So if that ever comes up, I just want to be perfectly transparent here that there is no relation there. They are now cheering for her and being very loud and very glad about that. I hope that they can hear her. And I hope that she or whoever is inside the courtroom can hear all of these hundreds and hundreds, probably thousands of nurses that have gathered to support her. This is unprecedented in nursing and in healthcare. And I'm really glad to see the turnout for her, especially considering where we are in healthcare today. So yeah, they're telling everyone now that if you want to watch the live stream that you can go to WSMV. I've got it pulled up here waiting to go. As soon as they go live, I'm going to switch live into the courtroom. It looks like we have 10 minutes left or so before they go live. But as soon as they do, I will be streaming that as well. Look through here and let's see. There are lots and lots of tweets coming out of here. Just look at all of the people here. And this was from about 30 minutes ago. I can't get it. There we go. I was clicking too much apparently, but this is from about 30 minutes ago. And again, that entire mall, if you weren't with us earlier, this is a big park-like mall area that is out in front of the courthouse. And it is right now covered with nurses from all over the country. I am in a Facebook group that's kind of following this, and there are people that have come in from Alaska. People are coming in from all over the country to support RaDonda and show support for her. And it's not that people are acknowledging that a mistake was made, right? But when does a mistake become criminal? And that, I think, is what is in question here. So I'm so glad to see that all these folks are out here supporting her. Again, that was just from 30 minutes ago. Again, this is the all of the people lined up to get inside of that courtroom this morning. And oh, here's another great live look. You can see this was from about 23 minutes ago or so. And there were, you can kind of get a sense of the size of the mall here by looking all the way back there. It extends pretty far. If you've never been there before, it is a large, expansive space. And the front of this tent, which I just love, it says "Nurses, Not Criminals." So I hope that they keep that. There it is. We are nurses, not criminals. Yeah, that about sums it up. So this is, again, being live streamed. WSMV is there. Some other news stations are there. I saw a lot of press out front when they spanned around, looking around to see what was going on. So I know that it's going to be widely covered. If you don't know, there was a Million Nurse March yesterday. So a Million Nurse March happened yesterday. That was in Washington, D.C., and that was spurred on somewhat by this, but really started before that. That Million Nurse March was about really kind of started when Congress got involved and wanted to cap pay wages or pay rates for travel nurses. Out of that, people were like, okay, this has got to stop. There's just too much going on. Nurses are not being valued the way that they should be valued, and they're often put at risk in these situations in hospital systems. So because of that, the Million Nurse March was born, and the reports that I wasn't widely covered as I think it should have been, but the reports that I'm seeing out from there yesterday was there were thousands and thousands of people, upwards of 20,000 people there. I'm waiting to get a final number on that, and as soon as I do, I'll bring that back to you. But they marched and they had a presence in Washington, D.C., and I think that's fantastic. And it just so happens that that was the day before RaDonda's sentencing. So we have two back-to-back marches happening that are highlighting nursing issues going on in our country and what we need to do as nurses to stand up and make sure that we are taking care of ourselves and that we are doing the right things for our patients, but we're doing them safely, right? Nurses don't want to hurt people. Nurses want to be there to take care of people, but we want to do it in a safe manner. And we don't want to be scared to go to work. We don't want to be scared because our staffing is short. We don't want to be scared because if we make a mistake, what do we do now? Do we own up to it and face going to jail or not? These are real conversations that are happening around the country. Ethically and morally, absolutely, we own up to it. And I think most people will. But it does give one pause. Is this going to be something that gives people a reason not to report those things when they happen because they're scared. They're scared for their livelihood. They're scared for their families. I mean, they're just scared. They're scared to be held criminally responsible for a mistake, for a meta error. So I think that it's really important that we have these conversations around the country and get to the bottom of what nurses are going through and really start making a difference. We have to start making a difference. And it's things like the march yesterday, things like being there for RaDonda today and standing up for her that are going to start moving the needle. People are going to start paying attention and moving the needle forward and making sure that we are actually having safe working conditions for nurses. We're being compensated appropriately, all of those things that should be happening, and that systems are held accountable when mistakes happen, not just nurses. So let's go and see if if the live has started yet. Oh, here we go. Okay, I am going to pop out of this and pop back in it so that I can make sure that we get the sound. So let me share the screen again. All right, here we go. Okay, so this is live court feed. You can probably hear the chatter in the background for this. They have not entered the courtroom yet. You can see that on the left-hand side of your screen. Let me make this a little bigger for you. On the left-hand side of your screen here, you can see the galley. This is where the judge will be when she comes in. They're getting this area prepared now. This is the witness stand over here. We might hear some, typically in sentencings, you will actually hear some words from the families and other things. So I'm interested to see who all speaks in the sentencing hearing. And then, of course, we will hear from the judge. So waiting to see what all we're going to happen here. There is sometimes, depending on the types of sentencing, there are arguments before and after. So I'm curious to see if there will be arguments. There are not, but anyway, here we are. This is inside the courtroom where RaDonda will be sentenced today. Hopefully it is the outcome that we all want, or that most of us want. So this is the courtroom where she will be sentenced. It is in the capital of Tennessee, which is Nashville. It is in the courthouse building there, and it's a very large complex, and I'm not sure exactly where this courtroom is in the complex, but I don't think that it's that far in because I've been there a few times, and this is one of the larger rooms. I recognize it. So let's see, what are they doing now? Okay, well, they're just kind of getting in. I'm just going to keep it up and just watch this. When they do come up, I'll pop it up there and let you know what's happening. So if you have any comments, please post them below. I'll pop them up on the screen and read them off, and we can have a discussion about it. As soon as they get going and people start coming in, I will make this full screen and just kind of be quiet so that we can hear them. But as you can see, there's some activity happening in there now. So hopeful that we can get a good view of what's going on here. It looks like we'll have a pretty decent angle. Okay, looks like they're playing with the feed, so we'll give that a minute. So as soon as the feed comes back up, I'll pop that back up. I'll keep an eye on it over here. So again, getting ready for the live stream of RaDonda Vaught's sentencing. I think that it'll be very interesting to see what's about to happen. Again, if you don't know what's going on with RaDonda Vaught, she is the nurse that was found criminally responsible for a medication error that ended in a patient's death, although that fact is questionable. She was convicted of it, but I fully expect if this sentencing, or even if it doesn't go in a way that that she gets a lot of time or whatever the case may be, I fully expect there to be an appeal of the conviction. Either way, there are a lot of things that have come to light. Like there is a 2.5 mils that are just seem to have disappeared out of the original syringe that she had. So you can go back, and I'm not going to pull that up, but you can find it. So if you go back and look, there is a comparison that shows what the original was based on what the internal investigation was, and then what the TBI had. So there is this missing medication in three different levels that are documented, which is really strange. So anyway, there's a lot of reason that I think that this can and will be appealed despite the outcome here today. But just waiting on the live stream to pop back up. It should be happening any time now. So we will see what's happening with that. Just waiting for that to happen. Anyway, there's so much that's going on with this. I really hope that this is the first step toward making things right for nurses. We are seeing an unprecedented level of people leaving the profession right now, and it's back. So let me just put it up here so you can see it. I'll just keep it running in the background, and I will expand it as soon as it comes up, as soon as the people actually start entering in the courtroom. She's supposed to be sentenced I guess the sentencing hearing starts in about 10 minutes. So I expect everyone to start coming in shortly. Usually the way these things work, everyone comes in before the judge. The judge will come in last, and when the judge comes in, then the proceedings start. So we will see what happens in this case. I'll keep it up here so that we can keep an eye on it. Again, if you have any comments, drop them down here and I can pop them up here. We can kind of have a live discussion about what's going on. Happy to do that. Sorry, it's early. Got to have the coffee, right? Coffee keeps us going. But yeah, so if you have any comments or anything, please drop them in there. Like I said, I'm going to keep this on just until they actually start. People are starting, they're starting to seat the galley now, so that's good. Pretty soon after everyone is seated, we're about 8 minutes out now, I think, from time when the court's supposed to start. So once everybody is seated and the defense and the prosecutory team, that's a hard word to say without a lot of coffee, when everyone comes in and gets seated, then the judge will come in and they will start. Again, we might have a little bit of argument from one side to the other, and I don't mean that like they're going to argue. I mean, it's like, they present, one side will present, the other side will present a little statement. We might hear from RaDonda herself. Sometimes that happens. Sometimes they'll read a letter. We just don't know. It'll be interesting to see what happens here. And then the judge will hand down the sentencing. So we will see. Just waiting to find out here what's going on. Again, there's a lot of support for RaDonda. I was showing some of the live feed outside of the courtroom. There is the entire mall area in front of the court is filled with RaDonda supporters right now, completely filled with RaDonda supporters. So very excited to see that. If you don't know, purple is the color that RaDonda loves, which is why purple is the color that is that most people are wearing. And you'll see some say, "I am RaDonda, nurse strong. I stand with RaDonda. I am a nurse, not a criminal. We're nurses, not criminals." There's all kinds of things that people are wearing in support of RaDonda for this hearing today. And they're actually chanting outside. And I heard a moment ago when I was looking at a Twitter feed from WSMV, they were chanting "RaDonda, RaDonda, RaDonda." So I hope that she can hear and feel all of the support that she's getting from the nursing community right now. And in the courtroom, as well as outside the courtroom, as well as inside the courtroom and across the country. So as soon as they go live, I'm going to make this, or as soon as the proceedings start, I'm going to make this large, and I'm going to shut up so that we can hear what they have to say. But this is a historic day for nursing, and I'm not overstating that. This is a very historic day for nursing. And like I said earlier, it doesn't matter what the outcome here is. I mean, it does matter, obviously, but I think this will be appealed. I think that her conviction will absolutely be appealed, but you have to go through the process. So sentencing comes first. At the end of today, I hope that we see RaDonda walk out of the courtroom, because it would be an absolute travesty if she ends up in jail. But well, let's just see what happens. So continuing to watch, you see me looking over to the side because I'm looking at this other monitor to see when they actually start this. Should be any time now. And this again is going to be a historic day for us in the nursing profession. Again, if you have any comments or you want to be part of the discussion, anything you want to talk about, just pop them down here below. Pop your comment below, and I can pop it up on the screen so that we can talk about it. Or if it's just a comment that you have that we don't necessarily have to talk about, if you just want to say something, we can pop it up there too. So just let me know. If you put it in there, I'll see it. And it looks like they are getting ready to call order. I see people coming in from the back. I think this is the team coming in. So I'm going to go ahead and make this larger. Let's see if I can make this larger. There we go. All right, so they're starting to come they're coming into the courtroom now. It's so hard to wait. It's pins and needles. Like, I woke up this morning and I couldn't even, I was just, I can't imagine what RaDonda's going through, that anticipation, that knot in your stomach. This just has such implications, definitely for her, but for our entire profession. And just the waiting is so difficult. But you see the teams are starting to come in now, so they will go back and check to see if the judge is ready, if the other team is ready. Once everybody comes in and the judge comes in, they will start. This is the feed from the Tennesseans, so they are adjusting their camera to try to get the best angle here. That's a pretty decent angle. I hope that they can turn it just a little bit more. It's like they're listening to me. So that we can see RaDonda too. And that is the table where she will be off to the side there. So it looks like they are getting ready to pull in all of the teams. And I wonder what the empty bench is about there. I wonder if that is her family or the family of the or the family of the patient who died. It's possible either way, but there is an empty bench there on the left-hand side of the court, which is typically the side that the plaintiff sits on. But in this case, the entire courtroom is so full, I'm not even sure. But that left-hand side where that empty bench is could be reserved for either RaDonda's family or the family of the patient that died, and in which case they're probably outside in the hall waiting and will come in and then sit in that bench as soon as as they go live, or as soon as the trial starts. They're live now, obviously. And that courtroom, if it's the same one that I'm thinking of, is a little, it's a little chilly. So, but I see people fanning, so I don't know. But that courtroom is typically a little chilly. If you see people in hats and scarves, in the past when I've been there for different things, usually, never on trial myself, but I've been there for different things. It's usually cold. So if you see people in hats and scarves, that's why. But right now everybody's fanning, so I guess it's not the case. And here comes RaDonda. And those must be the people that were with her, supporting her, her family members, and probably friends, I presume. So here is RaDonda now. And she looks pretty calm today, way more calm than I would be. She's got a lot of support in the courtroom and around the country. So I hope she feels that. I hope she heard those folks out on the lawn chanting for her. I hope she feels the support when she looks around the courtroom and sees the people there that are there for her. So I can't imagine what she's feeling right now. I'm just, sending out positive vibes for her. And it would be remiss of me to say that this is not painful for the family of the patient that died. I can't imagine what it would be like to be on either side right now. This just has such large implications for our profession as a whole, which is why I am really, my heart is just bleeding for RaDonda right now because of all of the things. It's been a really difficult time for her too. And for those of you who don't know, my channel is called The Academic Nurse because I am in academia and I do have students. And I've started to get some worrisome comments and calls from students who are concerned about, did I make the right choice? Now that nurses are going to be criminalized, I don't know if this is something I want to do. And that's heartbreaking to me. So I think that we need to make sure that we understand what's going on. We present all of the facts, not just the fluff that's out there, but the facts, the real facts of the case, so that we can have real information that we give to nurses and nursing students and show real support. So again, she is here it looks like she is waiting for the prosecution to come in. And that should be any second now. And then the judge will be closely behind. Again, if you have a comment, just pop it down below and I can put it up on the screen. You can, if you have a question, we can talk about it. If you don't have a question, you just want to comment something for the stream, go ahead and put it in the chat. I'll pop it up there so everyone can see it. But it looks like she's getting everyone's getting set for the sentencing. I don't know how long this will go on. It could be very short. It could be maybe an hour, maybe 2 hours. I've seen sentencing hearings that last days. I don't think that this is going to last days, but I wouldn't be surprised if we're here for a couple of hours during this. So just watching here to see what's going on. And it looks like she's just conferring with perhaps as part of her legal counsel. It looks to be so. People don't typically clutch a thing of papers that way unless they're with the legal team sitting back there. So perhaps that is part of her legal counsel. So she's just getting set. I can't imagine how nervous she is right now, but I'm just hopeful that, again, that she feels all the support that we have out there for her. That's part of her legal team that you see sitting there. So there are people here that are supporting her. And, okay, here comes the other team. They're circling around behind her and they will go sit at the desk on the other side. Yeah, I was concerned that with that camera view, RaDonda might be blocked. So I hope that the Tennessean or whoever is streaming this We'll adjust that feed just a little bit so maybe we can get a better angle on her, because it looks like, I think that's Mr. Funk sitting there. I think his head is blocking the view of her. He's probably going to tell everyone just kind of the rules of court. Oh, they're still setting up. Okay. So it's getting close, folks. These are the final things that have to happen. Usually there is some direction to the folks sitting out in the galleys so they know kind of what court decorum is, like don't speak, don't do this, don't do that. And then the judge will come in. In some cases they have people rise and some they don't. So that is the family that you're seeing coming in of the patient that died. And that is what happened there. I knew that they were reserving that bench, and that is her family. And my heart goes out to them as well today, too, because I can't imagine having to relive this and relive this and relive this, as this is probably the third or fourth time they've had to go through this. So while they're getting set, I assumed that they would be the last ones in the courtroom. While they're getting set up front too, and pretty soon the judge will be the next one ushered in, and then we'll go from there. So they should be coming in any second, or the judge should be coming in any second, and then the actual sentencing part will start. Sorry, y'all. Coffee is life these days. You know what I mean? Coffee is life. Again, if you have any comments throughout this, pop them up on the screen. I am not going to jabber on through the sentencing hearing. I want to hear what they have to say. But if there is a pause, or if there's some time for a little commentary, we might do that. But once it starts, I'm going to be quiet and just let this thing play out. So yeah, there's RaDonda. That's a good view of her. Hopefully we can keep that camera angle, or keep the angle where we can actually see her when they widen it back out, because when the prosecution, when their team came in and sat down, his head blocked the view of RaDonda. So I hope that they can get that fixed so that we can see her and her reactions throughout the sentencing hearing as well. So again, everyone is set, so they should start just shortly. There we go.
Criminal Court Division Board is now in session. The Honorable Jennifer Smith presiding. Be seated, please.
Good morning. Got a couple of things on the docket this morning, so we're going to take care of a quick matter. In state of Tennessee versus Ara Packmeyer. Do we have the parties here on that? Mr. Kelly? Where are you, Mr. Kelly? Oh, here's Mr. Kelly. We have General Yarborough.
You're on. He's in the vestibule.
Okay. All right. So I'm not sure what they're doing here. It sounds like they're trying to do something else first, which I hope is not the case. All right, go ahead with the announcement, Mr. Kelly. Oh, it's an announcement. I hope they fixed their sound. They need to turn on the microphones.
Sure how your honor wants her to report. Do you want to set a court date certain within the next 30 days for her to just appear?
We can do that, and that's usually the easiest way to do it. We'll just set it. Let's see, this is the 13th. Mr. Kelly, do you have a preference within the next 30 days? So they're setting a court date for a different matter right now. I assume as soon as this is over, which should only take seconds more, that they will. That the the actual
Ms. Packmeyer,
case
you
will start.
Report here
Hearing will
at
start.
9 o'clock, and you'll be on the docket. We'll call your name, and when your name is called, you can just step back in the back and get you processed.
And that should be it for us.
Okay, and you're going to meet with Ms. Christian? Yes, ma'am. Okay, all right. All right, we'll see you back here, Ms. Packmeyer, on June the 10th. All right, thank you.
So they just moved another matter later on this that had nothing to do with this case. They were just setting a date for a different
We have
matter.
one other matter on the docket, but I don't see Mr.
So apparently there is another matter that they need to reschedule, but
Information on Mr. Wright.
they don't.
Noon. So that leaves State of Tennessee versus RaDonda Vaught. We're here.
Here we go.
On that matter for a sentencing hearing. Is the state ready on that? Okay, is the defense ready, Mr. Trias?
Yes, Your Honor. Good morning.
All right, good morning. Okay. Get mine.
So if you're just joining us, it is starting now. If you have any comments, please put them in the bottom.
This is
I'll
case
pop them on
number
the screen.
2019 A76, State of Tennessee versus RaDonda Vaught. We're here today for sentencing hearing. So the state, you may call your first witness or present your first item of proof. Oh, actually, before we begin, Mr. General Jackson, I do want to place one thing on the record. In the time since we were here for trial and up to this point, the court has received a number of items of correspondence, letters, voicemails related to this case. And I certainly understand and appreciate there's a lot of public interest in the case. We have collected those letters. My staff has collected them. Voicemails have been reduced to writing by the court reporter. Those materials have been placed in the court file. The court has not considered those. It would not be appropriate for the court to consider them. So we provided copies to counsel for both parties for whatever use they want to make of those in this proceeding. So, all right, go ahead, Joe.
They are part of the court record.
Yes, sir. They're part of the court file. They'll be contained with the court record, but it is not matters this court has to confine its consideration to the evidence presented at trial and in this sentencing hearing. So they have been collected as part of the public record, and they are in the separate file, but part of the court file.
So they don't need to be marked as an exhibit to these proceedings, part of the record in this case.
It's part of the court file, yes, sir. It's not, it hasn't been, they have not been introduced as an exhibit to this proceeding. And I'm not going to consider anything that's not properly introduced as an exhibit to this proceeding. Does that make sense? But it is in the court file because we received it in connection with this case.
My only concern is if there's any review of this matter, I want to make sure that it would be part of the record that would be transmitted to the Court of Criminal Appeals.
Now, I don't believe it would be automatically transmitted unless you designated it. It's not made an exhibit to the proceeding.
And Your Honor, I don't intend to get into any of the materials that you received, but I think to protect the record, I've got what purports to be copies of all of the information the court has received. Could we make this an exhibit to this hearing, just so it is part of the record?
General?
I think the defendant would have to adopt it in some way to introduce that. I don't think it can just be put it along the foundation or things like that. Of course, consideration. I believe there's a case law about that. And a procedure would be to send them to present them, sort of include in the present report, and the judge could review that or peruse that as part of the ruling. Anything the defendant submits can be taken into advisement as part of consideration. I just don't think that coming in our launch without information or anything else would be appropriate. But I'll leave it up to you, Judge. I know you know which way you'll not.
Well, I mean, I think that is a concern just to introduce, because as I said, I've not reviewed them because it would not have been appropriate for me to review them at that time. I don't know who they're from. I don't know that there's been any foundation other than these are just materials that the court received just independently of this proceeding. So, if Mr. Trice, if you would like for it to be included and supplemented as part of the pre-sentence report, I wouldn't have a problem with that.
Because I think the court has already really laid a foundation based on the comments that she made to the bench this morning. And again, I'm not going to be them in any way. I just wanted to make sure the record was complete.
You just want it to be included within
Yes,
the
sir.
record for any review. I mean, I don't have a problem with that, and however we need to make that happen. I like the proposal from the state that it be included as a supplement to the pre-sentence report, since it hasn't come in as a matter of evidence, either at trial or at this point in the sentencing hearing. And I know that Mr. Strike, she presented a number of, provided to the court a number of letters in support as well, which would be part of this sentencing hearing, and the court has considered that. So,
I think we could start off then by just addressing.
all right, so why don't we do that?
Before we get into that, Your Honor, typically I do address any errors or corrections that the state would like to make.
Okay.
Just for clarification, for attention, on page 8 of the pre-sentence report, below the employment information and the comments below that, I guess we're considered the third paragraph under comments. Before was, she lost the job at HCA TriStar when the license was revoked due to the current conviction. And as a point of clarification, the state would like to introduce the certified copy of the order from the nursing board. This shows that the conviction was in July of 2021. This conviction, of course, not occurred until March of this year, so that probably needs to be clarified for some reference that wasn't the reason she was let go. And also, she was terminated, she was terminated from Vanderbilt due to current conflicts. I guess it could be due to the current facts or the facts of the situation, but again, she wasn't charged until March of 2019. So we would like to introduce the pre-sentence report for that, and then the copy of the certified order
All right.
as a clarification.
Mr. Strike, any response to those corrections or
Yeah,
changes?
those are accurate statements.
All right. The pre-sentence report will be corrected to that extent.
And I suppose we could, Mr. Starnes could, if you wanted to make those letters we had, you could to that percent report. We won't object, other than noting that some of the letters are duplicitous, they are the same format and content, and basically the same verbiage and signed by multiple people, but you'll know what to do back. when you see it.
All right, so Mr. Strike, we will introduce.
So he doesn't like form letters.
As part of the pre-sentence investigation report, the letters as a supplement.
But we all have the same message.
That will now be officially part of the record.
And Judge, one other housekeeping matter, I received over 160 letters and things that I put on a flash drive. These were the unsolicited ones, not the character letters, the 40 character letters that I filed with the court. Do you have that marked as well?
No objection, Your Honor.
Does the state, have you provided the state copies of that?
I can do them.
Okay, all right. Well, that will be, the investigation, pre-sentence investigation report will be supplemented with those complaints.
Thank you, Judge.
That'll be exhibit 1 to this proceeding. State may call your first witness.
State calls Gary Murphy. Okay, sorry, Your Honor, he's having vocal trouble. Call Michael Murphy. Stand here, raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
Could you say and spell your name for the record, please?
C-H-A-E-L-U-R-P-H-E-Y.
Just ask you to speak up, kind of project a little bit, those microphones pick up just a little bit, or you can move it closer to yourself. So, Mr. Murphy, how are you related to the late Charlie Murphy?
That was my mother.
And how many siblings do you have?
One,
All right, and who was your sibling?
Gary.
Do you wish to tell the court how the loss of your mother and everything that has transpired since December 26, 2017 has affected you?
Yes, sir. It's really played a big toll on me. It's, I was at work when all this took place and I didn't get to say bye to my mom.
didn't get together or hug or kiss. And when they brought her back up, she had tubes run down in her throat and stuff. And, you know, my dad suffers every day from this. He goes out to the graveyard once, anywhere from 3 to 4 times a week, and just sits out there and cries over it. Dad's 83 years old. And, you know, it's hard to sit back and see him suffering and crying and stuff over all this.
How has this affected you, the loss of your mother?
It's affected me pretty good. It's, you know, it's just every time you lay your head down to go to sleep, you know, I see the tubes running in there and stuff, and it really bothers me. And, you know, within the last month, I've really just started dealing with it.
And what are you doing to deal with it? Are you going to therapy, or are you just talking through it?
I've been going out there and spending a lot of time at the grave site talking and stuff. That's seemed to help out a lot.
Is there anything you wish to tell the judge about how you feel that this law should be sentenced?
No, knowing my mom, the way my mom was and stuff, she was there for no jail time. You know, that's just, mom was a very forgiving person.
How about your father? Did you discuss it with him?
Yes, sir.
What was your father?
Dad, you just have to understand Dad. He just says that he thinks that she should pull the maximum sentence.
And is that because, how long were your father and
57 years.
And was there anybody step in to the role of your mother after she passed?
Well, my sister-in-law stepped in and she took care of, you know, taking care of the bills and making sure he gets his medicine and doing errands for him and stuff like that. You know, the doctors with him and stuff.
That's all I have. Good morning, Mr. Murphy.
Morning.
My name is Peter Cheyenne. I'm a Nashville, Florida representative of RaDonda Vaught. And I'm so sorry for the loss of your mother. Your family has been particularly gracious throughout this entire process. Do you remember in December of 2017 when your mom passed that a family representative spoke to the Tennessean?
Yes, sir.
And was very gracious in the family's comments at that point in time.
Yes, sir.
Do you remember what was reported by the Tennessean about the feelings of your family back then?
No, sir, I sure don't.
It's sort of what you told the court early in your testimony today. Do you remember the family representative saying that mother would forgive the nurse alleged to be responsible?
Yes, sir. Yes, sir.
Was that an accurate statement?
Yes, sir.
And that your mother would be very upset knowing that this lady may spend some of her life in prison?
Yes, sir.
Thank you, Mr. Murphy.
Nothing further, Your Honor.
So I think the other sibling, Gary, Miss Murphy's other son, should come next. Nope, it's not Gary.
Stand up, raise your right hand.
You swear to affirm that the testimony you're about to give will be the truth, so help you God.
Can you say and spell your name for the record, please?
RaDonda Murphy, RaDonda Murphy.
And how are you related to the late child?
I'm her daughter-in-law.
And can you tell the court how the loss of Ms. Murphy is affecting your family?
I'm with my father-in-law quite a bit. I try to take my mother-in-law's place and doing things for him, and just watching the hurt that everybody's gone through. It's like my father-in-law said, it would be a whole lot easier to be able to deal with this if it was natural. But with, to add on to what my brother-in-law said, I talked in great lengths with my father-in-law about this whole situation. And he doesn't want to see RaDonda go away for jail for many years. He really doesn't want that. But he does feel like that her life was taken, and it's just hard for him to deal with it. And then I watch my husband suffer. I watch my brother-in-law suffer. And it does take a toll on you. It'll break you down if you're not careful. I've had to ask God for strength many days. And just the hurt that everybody's gone through. I mean, it's sad all the way around for everybody. I mean, not only my family, but hers also. It's just hard. I stop and I try to think to myself, and you try to find forgiveness, and you just wonder, like, how many mistakes do you have to make before it becomes a choice? And I can't seem to find the answer to that.
That's a good point.
But just the hurt that I watch my family go through is horrible. It's absolutely horrible. And I try to be strong for them, but at times it's hard.
Do you have children?
Yes, sir.
How many children do you have?
I have 2.
And how old were they when Charlie passed?
Oh, it was 4 years ago. 33 and 34. 34 and 32.
And you've also got grandchildren?
Yes, sir. I have 4. But she never got to see her last one.
I believe that's all I have here.
Judge, I have no questions for Ms. Murphy.
Thank you.
Yes, Your Honor, State Hall, Chandra Murphy.
So another family member is coming up now. I think they said Chandra Murphy.
You swear or affirm that the testimony you're about to give will be the truth, so help you God.
Ms. Murphy, please state and spell your name for the record.
Chandra Murphy. CHANDRA MURPHEY.
Ms. Murphy, I know you testified at the trial, and you were present during the trial. And now it's your opportunity to tell the judge how the loss of your mother-in-law has impacted you.
Well, it's impacted me because it's played a big role on our family, my marriage. We just feel that my mother-in-law got lost in all this, that it wasn't really about her. We've been harassed by Channel 5 News, knocking on my door, taking pictures of my house, questioning stuff that I've done and signed, and was it legit? And we've just been harassed. I haven't had peace, nor our families had peace in 4.5 years. And when you lose a loved one, all you want is closure. And we haven't had that. This has been ongoing for 4.5 years. And it's just been sickening to us.
How, you mentioned your husband, and who is your husband?
Michael Murphy.
Who we just heard from? What about
So her husband's the first witness.
Well, it's affected them too. My kids are kind of quiet and keep their emotions to themselves. But we would always get together and have Sunday dinners. We had a holiday get-togethers. And the kids, grandkids were all involved in it. We go yard selling with grandma, shopping with her, and we just did so much together as a family, and it just ended in a split second for us. I mean, it's like I stated last time, we still got her Christmas presents in our attic wrapped. And it's very hurtful when we have to get up there and look at that. But we just want peace and closure.
As far as sentencing, what would you like to tell the judge about how you think the defendant should be sentenced?
Well, speaking on behalf of my father-in-law, you know, because we deal with him quite often and he cries every day. We talk to him on the phone, he goes to talking about it. And it hurts us to see him hurt so bad, and he has stated that he wanted her to have the max. But on our behalf, we forgive her. We forgive her. Do we think she actually intentionally went in there and said, I'm gonna kill Miss Charlene today? No, we don't. We forgive her. My mother-in-law would want her to be forgiven. And jail time is not an option to me
Wow.
for her.
Is there anything else you all like to tell the judge?
No, just in the past 4.5 years, our family's been waiting, and it's been nice to have heard at least, I'm sorry, come out of her mouth, and it hasn't. But deep down, we're sure she is sorry, but it would have been nice to at least hear I'm sorry with all the media and stuff being said to them, and never once, you know, was it sympathized for, I'm sorry, you know.
Oh, that's tough.
Thank you for filling the question.
Just one question. Good morning, Ms. Murphy.
Good morning.
I think you appeared as a witness in the trial of the case, is that right?
Yes, sir.
And since you were a witness, you were not able to be in the courtroom when the evidence was being presented, is that right?
Yes, sir.
Were you ever able to hear the 2-hour or so interview that RaDonda Vaught had given to Special Agent Ramona Smith with the
Oh.
FBI?
I've heard bits and pieces, not the whole thing.
In the bits and pieces that you heard, did you hear RaDonda Vaught being very emotional and regretful and remorseful for her mistake?
I heard bits and pieces of it, but her talking to the TBI has nothing with standing on the media in front of the News Channel 5 and not saying it to the public and everybody for an apology to the family.
I understand. Thank you.
It sounds like they're calling the TBI agent now that did that really long interview with her.
Good morning, Agent Smith. Will you please state and spell your name for the record?
My name is Ramona Smith, RaMonaSmith.
And Agent Smith, you are the TBI agent who investigated the particular case that we're here on for sentencing. Is that accurate?
Yes, ma'am, I
And
did.
you testified in this trial previously. Now, this court has heard all of the testimony since Your Honor presided over the proceedings. So I want to specifically talk about a separate incident with respect to Ms. Vaught. So I want to direct your attention to August of 2020. Do you recall an incident that you were notified about involving the defendant today, RaDonda Vaught?
Yes, ma'am, I do.
Okay. And can you tell the court a little bit about how you became involved with that?
Our general counsel contacted me, Jeannie Broadwell contacted me regarding a matter to see if RaDonda Vaught was still under indictment or if that situation had been resolved. And I asked her why, and she said that there was an attempt to purchase firearms at a local store in Gallatin, and they had to deny it, but they had to confirm that she was still under indictment.
Now, let me stop you for just a moment. Do you recall when Ms. Vaught was indicted in this particular case, 2018-A-76?
February,
February of
2019. I believe it was like January, February, I don't remember the exact date. She was arrested on February 4th.
Now, based upon the information that you were provided, were you actually assigned by the Tennessee Bureau of Investigation to investigate this particular incident?
I was.
Okay. And can you tell the court a little bit about how your investigation proceeded?
Based on the information I was provided, I went to the gun store in Gallatin and reached out to the individual, spoke with the individual, Nathan Gregory, who conducted the business with Ms. Vaught that day when she came into the store. In talking with him, she had come in and filled out the federal form, which is required for purchasing any firearms, any type of equipment, any type of pieces. He showed me the form where she had filled it out and signed it, and that she was denied, and he submitted her denial form. And then
Let me stop you if I can right there. What is submitted a denial form mean?
so when you go in to purchase a gun or any type of part for a gun, you have a background check done through the Tennessee Instant Check System, which is the Tennessee Bureau of Investigation. We manage that. Goes through the system and they check you for a background of criminal histories, indictments, things along those lines. And the TBI then sends a denial if there's anything they find as part of that background that would prevent them from purchasing a firearm. They then send the denial form back to the store. He does not know why it's denied. All he knows is that it's been denied.
Now, is there a way to appeal that denial?
There is, and we informed her of the denial. It's almost instantaneous. That's why it's called Tennessee Instant Check, because it's done quickly. And so he told her it was denied, so she filled out a denial form, appeal form, and that is sent back to the Bureau. And then that takes a little more time, because then they have to go through the process of reviewing it.
Now, do you happen to have a copy of the firearms transaction record that Ms. RaDonda Vaught filled out that particular day?
I do. I left it in my seat, but I do have a copy of it. Yes.
May I approach Your Honor?
I am not sure where she's going with this. I mean, it seems to me like this should be, if this was an issue, it should have been evidence in the trial, since this happened in 2020, and not necessarily something in the sentencing hearing. So not real sure where she's going with this.
I want to direct your attention to number 11 on page 1 of 6. If you look at section A, lowercase a, can you read that line?
The entire thing, or just the first part?
Just the first part.
Are you the actual transferee buyer of the firearm listed on the form?
And what did Ms. Vaught check?
Yes.
Now, let me direct your attention to section B right underneath. Could you please read that line?
Are you under indictment or information in any court for a felony or any other crimes for which the judge could imprison you for more than 1 year?
And what did Ms. Vaught check there?
No.
Now, I want to direct your attention to page 2 at the very top. And if you could go down to maybe the middle of the paragraph where it says, I also understand that making, and if you could read that line.
I also understand that making any false oral or written statement or exhibiting any false or misrepresented identification with respect to this transaction is a crime punishable as a felony under federal law and may also violate state or local laws.
Then charge her separately. Has nothing to do with this.
Tell the court who signed that document and what the date.
RaDonda Vaught on May 27th, no, I apologize, August 27th of 2020.
Your Honor, could you make this state's exhibit number 2? It is exhibit 2. Now, Agent Smith, based upon your investigation into this particular matter, was Ms. Vaught charged?
Yes, she was.
May I approach Your Honor?
an affidavit of complaint for taking out a warrant for the arrest of an individual.
Okay, and what warrant, whose name is listed on that warrant?
RaDonda Vaught,
Okay, and in what county was that?
Sumner.
And what was Ms. Vaught charged with at that time?
She was charged. I'm sorry, hold on just a second. Perjury, I apologize. A perjury of TCA 3916-702.
Your Honor, that, I believe, is a certified copy. We can amend that as the state's next exhibit.
You did this is it through.
Now, Agent Smith, upon following up, did you have the opportunity to speak with the owner of the Blue Line gun store? Okay.
Yes.
And what did he tell you about his interaction with Ms. Vaught that day?
Hearsay.
Well, she came in, filled out the form, did the appeal, and then left. And then later that afternoon, she called in and said to him, "Oh, I think I have this court thing going on in Davidson County. That may be why they declined it, or they denied it."
This court thing?
Mm-hmm. Yes, ma'am.
Now, Agent Smith, were you present in the courtroom during the testimony of Sean Murphy? Today?
Today, yes.
And did you hear Mr. Stryan ask Ms. Murphy a question about Ms. Vaught being remorseful in her interview with you?
I did.
And I want to ask you, since you were the agent that conducted the interview, what is your interpretation of the way Ms. Vaught was acting when she did become upset?
In the course of an interview with an individual, you develop rapport with that individual. It means you have to empathize with them at times in their situation and what they've done, and help them to understand that to get that off your chest is soul saving, if you will. And she was very forthcoming. But she didn't seem shook by it because until she found out that they were both from that page. Her remorse during the case was of the attitude, in my opinion, as an investigator, that she felt by telling the truth it would all go away and that she should be rewarded for being honest. And I appreciate honesty. Honesty is an amazing thing. I don't find a lot of it in my line of work. But it doesn't take away accountability. And I don't think that she feels she should be accountable. She feels someone else should be accountable. She was remorseful more for the fact that she knew this was going to go badly in the criminal aspect, in the sense that it wasn't just administrative anymore. It became a criminal issue. And anytime anyone is charged with a criminal issue, they do tend to panic internally. That's just what they do, because they know there's a potential for jail time and no one wants their freedoms taken away.
I want to direct your attention. Were you present every day or most of the time when you could be in the courtroom for the trial on this matter?
I was.
And were you present after final arguments in this case?
I was.
Your Honor, at this time, we would like to play a snippet of an interview, and then I'll certainly ask Agent Smith who is identified.
It's very obvious by the district attorney's actions, the assistant DAs that are prosecuting this case.
Agent Smith, do you know who is giving an interview in this case?
That is Ms. Vaught.
Okay, and you see Ms. Vaught in the courtroom today?
I do.
It's very obvious by the district attorney's actions, the assistant DAs that are prosecuting this case, all three of them, and their lives. It is very obvious. They don't know shit about healthcare. They don't give a fuck
about nurses. Hear what Chad Jackson says.
Agent Smith, do you recall when this interview took place, at what point in time during the trial proceedings?
Yes, ma'am, it was between closing arguments and the verdict.
That's the question, please. Your Honor, if we could introduce, this particular sentence.
You had it on.
Yes, sir.
All right. All right. We did it before.
Morning, Special Agent Smith.
So she was just mad that she got called out, apparently.
Blue Line gun store incident first. TBI was the lead investigating agency on the Charles Murphy case, is that right?
Yes, sir.
I think you arrested RaDonda Vaught on the indictment, on the arrest warrant that was issued on the indictment on February 4th of 2019, is that right?
Yes, sir.
And I believe the event at the Blue Line gun store happened on August the 20th, 2020, is that right?
It was August 27th of 2020, yes, sir.
And then about a year later, August 18th of 2021, is when the General Sessions warrant was issued in Sumner County, is that right?
Yes, sir.
One of your colleagues went up to Sumner County and secured that arrest warrant, is that right?
Yes, sir.
So there was an entire year between the event and the decision by TBI to seek charges in this case, is that right, or in the Sumner County case?
It takes time to develop and investigate a case, yes, sir.
Did you investigate the case, or did your colleague Dean?
I investigated this case.
And you said that you interviewed a young man that worked at Blue Line gun store, is that right?
Yes, sir.
Is that Randy Gregory?
Nathan Gregory.
Nathan Gregory.
Yes, sir.
I think you were asked a question about interviewing the owner of the gun store. You didn't really interview the owner, you interviewed Nathan Gregory, is that right?
I interviewed Nathan Gregory and did discuss it with the owner who was there. He's Nathan Gregory's father.
And I'm sure the owner told you it's a father-son ownership of that gun store, is that right?
Yes, sir.
And I'm sure he shared with you that RaDonda Vaught and her husband were regular customers at the gun store, is that right?
Yes, sir.
And I think they had at least a 3-year relationship with this family.
I don't know that. No, sir.
When you interviewed Nathan Gregory, did he tell you that it was pretty common for that incident check to come back denied?
I don't know about common. I know it does happen, yes.
And I think he told you, consistent with your testimony, that later that same day, maybe within hours of the event, his boss called the gun store and said, I think I know why that may have happened.
Yes.
Is that right? Now, do you have State's Exhibit number 2 in front of you?
No, sir, I do not.
Could you, That is the Bureau of Alcohol, Tobacco, and Firearms, a federal agency's firearm transaction record. Is that right?
Yes, sir.
And these alleged false statements on a ATF 4473 form are typically investigated by the Bureau of Alcohol, Tobacco, and Firearms. Is that right?
We can work in conjunction with them, yes, sir.
And how many of these ATF 4473 cases have you personally investigated before this one?
This was my first.
Now, you were shown State's Exhibit 2, and according to the Sumner County affidavit in support of the warrant, you're focused on question B, is that right?
Yes, sir.
And I think it's 11B for the record, is that right?
Yes, sir.
And let me read this, and you tell me if I'm reading it correctly. Are you, and the you would be the person who's seeking eligibility to purchase a firearm, is that right?
Correct.
Are you under indictment or information in any court for a felony or any other crime for which the judge could imprison you for more than 1 year? Is that
That
right?
is exactly what it said, yes, sir.
And it was TBI's insistence that there was a willful false statement made in this application that was presented to the court. Is that right?
It's very straightforward. It's 2 boxes, yes or no, and she marked no.
And I think it's fair to say this case has been pending a long time, is that right?
It's been active a long time, yes, sir.
And there were obviously some discussions along the way as to whether this case could be settled in some way. Is that a fair characterization?
There were several discussions along the way, yes, sir.
And I'm sure that the district attorney's office kept you aware of those discussions.
Very much so, yes.
And there were even discussions about whether it could be settled maybe on a probationary sentence.
That's pertinent to these proceedings or even to the trial.
It's very pertinent.
I'm not trying to get into the settlement, I'm just trying to focus on which the judge could imprison you for more than 1 year. That's one of the elements of the question that's put to the purchaser, the prospective purchaser of a firearm.
It is one of the elements of the question. However, another element of that question states very clearly, are you under indictment or information in any court for a felony? And she was very well aware she was under indictment and been arrested for 2 felonies.
And then in the disjunctive, it says, or any other crime for which the judge could imprison you for more than 1 year. Is that right?
By felony, the definition is more than 1 year in prison.
Well, you know that, and I know that, and the judge knows that, and the prosecutor knows that.
But anyone that is being charged with a crime and has met with an attorney such as yourself is very well aware of what a felony is about and how long they could be sentenced to court. Or to prison.
Maybe.
It's very well aware and it's commonly discussed between a defense attorney and their client, as you would know.
Now, this was said before Judge Michael Carter.
Ooh, sass.
Of the Sumner County General Sessions Court on May 4th of this year, is that right?
Yes, sir.
And Ms. Vaught and I were there in court, we didn't see you there that day.
May 4th, I was not there, I had other obligations, yes, sir.
So did you have an opportunity to talk to District Attorney General Ray Whitley or the assistant that was covering the case that day?
I have spoken with General Boyano, yes, sir.
And there was really no need for you to come to Sumner County that day, is that right?
There was no need for us to come to Sumner County because we weren't having any type of a hearing. Agents go to court cases whether they're required to or not if they are available to keep up to speed.
But I would like to think that Assistant District Attorney Christopher Boyano or the District Attorney Ray Whitley would have had the courtesy to tell you that they were not going to prosecute this case.
They would have if that was the case. But in the discussion I had with Mr. Boyano, that was not the discussion we
Did
had.
Mr. Boyano tell you that they were going to suggest to Judge Carter that the case be taken under advisement for some period of time and then be dismissed?
General Boyano stated they are going to take into consideration sentencing today and then make a decision if that's the way they are going to proceed. There was no definitives in any of it.
In your mind, it was not definitive.
No, sir. And I clarified that with General Boyano yesterday.
He told you that it's not going to be taken under advisement and dismissed?
No, sir. He said it is going to be taken under advisement what the sentence is today, and it is a possibility that it will be monitored for a year and then dismissed. But it was not said flat out that that was what he was going to do. And as a general rule, prosecutors don't settle cases unless they reach out to the agent to make sure everyone's on the same page.
What, did you have a discussion with them before May the 4th?
I've spoken with him several times.
Because you didn't appear on May the 4th, but because there was nothing that was going to happen.
There was, like I said, I had other commitments that day.
You talked about your interview of RaDonda Vaught, and that's, so it's clear from the record, it's the interview that was played to the trial jury in this case, is that right?
Yes, sir.
And by my recollection, it was about 2 hours or so.
It was.
And it was a very emotional interview for RaDonda Vaught, is it not?
Depends on how you define very emotional. I didn't find she was very emotional. I could tell it was trying on her, but she was not what I would consider remorsefully.
But you will concede that she was extremely transparent in what she was telling you about the events of this medication error, will you not?
Yes.
In fact, she truthfully disclosed to you how distracted she was that day and other things that were going on that sort of deflected her attention from things that she should have been doing.
Oh, yes, she admitted that she was distracted multiple times over and over and over.
And frankly, those candid.
Why is she so hostile?
Really made out all the elements of the lesser included offense of the jury convicted. Is that right?
Candid admissions, what do you mean by that?
What she told you, what she honestly disclosed to you on that 2-hour report, basically is criminally negligent homicide.
That's what the jury found, yes.
And you told the judge that one of your interview techniques is to make sure that you try to understand the subject and maybe even empathize with the subject. Is that right?
Yes, sir.
And you noted at the conclusion of that interview that you were very empathetic with RaDonda Vaught.
I was very empathetic with her, and I appreciated her forthcoming, and I shared that with the Attorney Generals. But that doesn't circumvent the seriousness of the amount of errors.
No one said
she
that.
did. We all deserve forgiveness.
In fact, you were so empathetic at the end, you were reassuring her, hey, we all make mistakes.
Right, we all make mistakes. I make mistakes, we all make mistakes. However, every day, today, simple mistakes don't cause the death of an individual that was charged to their care.
That was my question.
So they're redirecting. Or just deciding if they're going to redirect.
Elizabeth Kessinger. Judge, just like you be sure, no one has invoked the rule yet. Is that right? That's right. Stand here, raise your right hand.
You swear or affirm that the testimony you're about to give will be the truth, so help you God.
Good morning, Nurse Kessinger.
Good morning.
If you could state your name to the court, please.
Elizabeth Kessinger.
And if you could, please keep your voice up. You've got a very soft voice and this is a big court. If you could spell your last name for the court reporter.
Kessinger.
And Ms. Kessinger, how are you employed?
I'm a nurse at Vanderbilt.
And how long have you worked at Vanderbilt University Medical Center?
14 years in June.
And where have you worked? What part of the hospital?
The neuro ICU.
The neurological intensive care unit?
Yes, sir.
All 14 years you've been in that unit?
Yes, sir.
And do you know the defendant in this case, RaDonda Vaught?
I do.
And if you would tell the judge how you came to know RaDonda.
I was a nurse there, obviously, when she was hired, and I was her preceptor after she was hired, and then her co-worker after that.
And just so it's clear for the record, it came up at the trial, what is a preceptor?
A preceptor is a nurse that onboards newcoming nurses and trains them in the care of our patient population, policies, procedures of the hospital and the unit in particular.
And did you serve in the role as a preceptor for RaDonda Vaught?
I did.
So you helped train her?
That's correct.
How much experience did she have when she came to the neuro ICU?
I think she had 2 years, maybe a year or two of experience.
While you were training her, what sort of impression did you have of her ability to learn the new position at the neuro ICU?
I think the main impression was how motivated she was. She would do a lot of work on her own as far as learning our patient population, the diagnoses, the treatments. And she was also very attentive with the patients, going in the room and spending not only time doing the care, but just spending quality time with them and reassuring them.
And I believe you worked with RaDonda between 2015 and 2017.
Yes.
Is that right?
Yes.
How would you describe RaDonda Vaught as a person?
I think she's generous and caring, for me, motivated as well, even as a person outside of the hospital, she's very motivated, and resilient.
In that 2 years that you got to observe her work in the neuro ICU unit, did she become in some ways a leader among the nurses on the sixth floor?
She did.
And in what way did she demonstrate that?
It was her patient care. I think that she always went above and beyond with the patients. And I have described her previously as a nurse's nurse, which means if one of us was sick, she would be our choice.
I think it's safe to say that in the neuro ICU unit, you have some very challenging patients. And describe for the record the type of patients that the neuro ICU nurses deal with on a daily basis.
It depends on which area you're working in. I think it was talked about previously that we have an ICU portion of the unit and then we have a step-down portion as well. The ICU are very high acuity patients with lots of comorbidities typically.
And let me stop you right there. When you say high acuity patients, what does that mean?
That means that as far as their illness and injury, there are multiple things that are going wrong.
Sickest of the sick.
You know, it's not just their neurologic injury that affects other systems of the body. So if there is a neurologic injury, that can affect their airway. It can affect other systems in the body. So.
And you mentioned comorbidities. What are comorbidities?
They are illnesses that patients have in addition to the injury that brought them into the hospital, which can obviously complicate the picture.
Can you tell the court a little bit about the culture of the intensive care unit, particularly the neurological intensive care unit?
It's very fast paced those days. There are just a lot of things going on at any given time. You're not just taking care of your patient. It's kind of a community. We help each other because some of the patients are so sick that it takes a team.
I want to direct your attention back to December 26th of 2017, the date that this error occurred with patient Charlie Murphy. Were you working that day?
I was not.
At the trial, it was established that RaDonda Vaught was functioning as the help all nurse on the sixth floor of the neuro ICU unit. What is the help all nurse?
The help all nurse is typically more experienced staff. And it's a nurse that helps with bedside procedures with physicians, helps the nurses with anything they may need during the day. We also serve as a mentor to all of the nurses. So if there is a knowledge gap, if there is questions that need to be asked by less experienced nurses, they would typically go to the help hall for that.
How does the role of the help all nurse compare with the bedside nurses that are in the neuro ICU?
The bedside nurses have an in-depth understanding of their patient. They know history, what brought them into the hospital, where they are in the course of their hospital stay, and what to expect for that shift and the shifts coming up. The help all gets a snapshot of each patient at the beginning of the shift. We have 36 beds, and we will sit in on charge report, and you know the patient's name, their admitting diagnosis, and their acuity is basically what you know.
This may sound like a silly question, but the nurses in the ICU unit, do they have to deal with distractions as part of the job?
Yes, absolutely.
And tell the court a little bit about the typical day in the life of an ICU nurse in terms of the distractions.
Oh, this will be interesting.
Well, first of all, are you asking about the help all or the bedside nurse?
So let's start with the help all.
The help all carries a phone, that is connected to all of the nurses. And then that phone is also listed in the computer, so physicians call them, other providers, case management, the charge nurse, and you carry that phone with you all the time and answer the phone when it rings, kind of no matter what's going on. And then we also carry a rapid response phone. We don't anymore, we did when RaDonda was working there. So if there is a rapid response called on one of our floors, we would respond to that as well.
And is the
Deep
health
breaths,
office
RaDonda.
also cast in the role of training throughout his or her shift?
Yes, at times, we will have orientees with us as well.
And if you had an orientee with you as a help all nurse, how does that factor into the calculus of distractions and things that have to be filtered?
Well, it can be a very big distraction because you're talking through everything that you're doing. And questions, because you're teaching, you're getting asked a lot of questions at the same time.
Have you had a chance to discuss this medication error and the consequences of it with RaDonda Vaught?
Yes, sir.
What can you tell the court about the effect that this has had on RaDonda?
I mean, I think for a significant period of time, it broke her.
I'm sorry, can you say that again?
I think for a significant period of time, it broke her. It broke her heart. And her heart is still broken in many ways. There's been talk that, you know, she is resilient and she has built a farm, but she still has a broken heart.
Has she expressed to you how she feels about Charlie and Murphy and the loss that the Murphy family has endured?
She's devastated and has been ever since. And she has said that she'll never get over it, and she knows that the family has suffered a terrible loss, and she understands what led to that loss.
We are going to be asking the court to consider alternative forms of punishment, specifically probation. If the judge saw fit to place RaDonda Vaught on probation, there would be numerous conditions that she would have to abide by. You've known RaDonda for how long at this point?
6 years?
Knowing her the way that you know her, do you think that she could abide by all the conditions of probation?
Yes, I do.
Those are my questions.
Good. I was not looking forward to a cross. Again, if you have comments, drop them in here. I will put them up.
Stand and raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
Good morning, Ms. Kelly.
Good morning,
If you could state your name for the court, please.
Kelly.
And you're going to need to spell both your first and your last name.
First name Kelly, last name Kelley.
And where do you live, Ms. Kelly?
I live in Andalusia, Alabama.
And do you know RaDonda Vaught?
I do.
And explain to Judge Smith how you know RaDonda.
RaDonda and I went to grade school together, so I have known RaDonda for many years, over 26 years.
So I guess this is a character witness.
You were in contact with RaDonda over those 26 years.
Absolutely.
Now, obviously RaDonda was born in Andalusia, Alabama.
I don't know where she was born. I know she was raised.
She may have been born in the Panhandle, but lived in Andalusia.
Yeah. Yes,
And you all went to school together.
we did.
How would you describe your relationship with RaDonda?
RaDonda's like a sister to me, so very close, like family.
And I believe you have children, is that right?
I do. I have two children.
And does RaDonda have a relationship with your children?
Of course she does. She doesn't have children of her own, but
but she's like a little mom of mine.
Describe for Judge Smith the RaDonda Vaught that you have known over the past almost 30 years.
RaDonda and I have known each other for, I'm so sorry.
Take your time.
We've known each other for many, many years, and I have seen just about every side of RaDonda that you could possibly know about a person. RaDonda is sweet, she's kind, she's loving, she's caring. She has got the sweetest soul. I call her sometimes whenever I just need a little bit of a pickup. She's always there, with a kind word. I love her dearly, and I just appreciate her always being there for me.
There came a point in time when RaDonda told you that she wanted to be a nurse, is that right?
Yes.
What was your reaction when you heard that RaDonda wanted to be a nurse and wanted to go to nursing school?
RaDonda, she'll be great at whatever she does. So when she said that, there wasn't a doubt in my mind that she would be so caring and loving, and, you know, she would give her patients the best care like she would if it was, you know, her own family. I mean, she's just so giving, and she doesn't ask for anything in return. She's just a giving person, and I knew that she would treat her patients in that same manner.
And did she possess those caring and loving and giving traits even before she went to nursing school?
Oh, yes, she's been like that since we were little.
You're probably her closest friend, is that right?
We've always been really close. Yes.
And I assume she spoke to you after this event at the Vanderbilt University Medical Center in December of 2017.
She did.
And what effect has all of this had on RaDonda in your estimation?
If tears were words, there would be many. We cried together a lot over this. Sometimes less words are more. We don't have to talk a whole lot about it. I know how she feels. I know the person that she is inside, and so there's no question as to whether or not she's broken about everything that's happened. There's no question about that. I think I don't really have to talk to her in depth about every little thing that happened because I don't really know all of that. I do not have a nursing background, so I don't know all the health stuff. But personally, I know that she's dealt with this very hard.
You know that she's lost her nursing license
I do.
and will never practice as a nurse again. What kind of work is she doing now?
She owns a farm.
And do you know roughly how long she and her husband have owned that farm?
It's been 6 years, 7. I don't really know the exact date, but it's been a while.
You visited the farm before, is that right?
We have.
You didn't operate the farm, is that right?
Yes, we own a farm, and so we go and get tips, take the children out.
And that is her life now, is that
It is.
You've heard me ask another witness about probation and whether that witness or you believes that RaDonda could abide by the conditions of probation. Knowing her the way that you know her, do you think that she could do that?
Without a doubt.
Do you think that she's got the mental discipline to follow any instructions of a probation officer?
Yes, I do. She'll be on the farm.
Thank you. No question, Your Honor. Call Becker Ray.
So now the third defense witness is coming up. I'll grab her name and pop her name up here on screen.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
Remember, if you have a comment, drop it below and I'll put it on screen.
Good morning.
State your name for the court, please.
It's Rebecca Ray, R-A-Y.
Thank you. Where do you live?
I live in Bethpage, Tennessee,
And how long have you lived in Bethpage?
since 2018.
And what brought you to Bethpage?
I'm not really sure what brought me to Bethpage, but I think I know now.
And when you moved to Bethpage, did you come to meet a person named RaDonda Vaught?
I did.
And explain to the judge how you came to meet RaDonda.
My husband and I were walking my granddaughter along the road, Old Mount Vernon Road, and her husband and her pulled up and said, "It's pretty dangerous to walk a baby on this road within a stroller," and they were concerned, and then they introduced themselves, and we both talked about I was a nurse practitioner, and I explained a little bit about myself, and she told me a little bit about herself, and then we just hit it off from there.
And you all became friends.
We did, yes.
And how close do you live to RaDonda's house?
Just a couple miles, but we live in a big farm community, so that's like next door.
How would you characterize your relationship with RaDonda?
RaDonda and I have really bonded over the last few years. I'm a nurse practitioner, and so my first year as a nurse was in the neuro ICU. I was also in labor and delivery, and I had a lot of different positions as a nurse, so we tended to tell a lot of just stories, just bonded over patient stories, and I really realized that she was the kind of nurse I was. She's the kind of person that I would want to take care of me. I'd want her to take care of my family. She just embodies the soul and strength and resilience of a nurse. And I just admire that in her so much. And I just have been so blessed to have her in my life.
I think you were here for every day of the trial, is that right?
I was.
You and your husband were here in support of RaDonda, is that correct?
Yes, we were.
What sort of qualities have you seen in RaDonda over the past few years that you've come to know her?
She is one of the most generous, loving, honest, caring people that I have ever known. And I mean, I don't have a lot of close people in my life, but I consider her one of the closest. I can tell her anything, even through all of this that's happened. Anything that's happening in my life, she's a listening ear. She's, anything, and so she's very special to me and to my family as well.
I think now she's exclusively on her farm, is that right?
That's correct.
You've heard the questions about probation. Do you think that she could abide by conditions of probation?
Absolutely, yes. I think she is an excellent candidate for probation.
Thank you.
Thank you.
I'm called Caitlin Stokes. Stand here, raise your right hand.
You swear or affirm that the testimony you're about to give will be the truth, so help you God.
Good morning, Ms. Stokes.
Good morning.
If you could state your name for the court, please.
Caitlin Stokes,
And if you could spell your first name for the court, please.
Kaitlyn.
And where do you live now?
I live in Bowling Green, Kentucky.
And how are you currently employed?
I'm a nurse practitioner with Commonwealth Health Corporation in Bowling Green, Kentucky.
And you know RaDonda Vaught.
Yes.
And explain to Judge Smith how you know RaDonda.
I went to nursing school with RaDonda, so we met in 2012. We became
essentially nursing school wives, is what we like to call it, because, we were best friends throughout nursing school, finished together, we both worked together.
We know how that
at
goes.
UNC, and we've remained friends since then, and she is my daughter's godmother now.
What were your observations after you all graduated and got to see RaDonda function as a nurse? What were your observations of her competency as a nurse?
I always like to tell people that RaDonda is a better nurse than I'll ever be, that she is the kind of nurse that I wish I was, because she's the kind that she takes the time with her patients to sit and explain to them things that no one else has. She will paint their nails, she will trim their toenails, she cares about the human experience genuinely and takes the time and effort to show that. She is thorough, she is competent, she is caring, she is, as others have stated, everything that you would want in a nurse.
It's a great compliment.
Her devotion to her patients during the shift, did that ever interfere with her ability to get her charting done within the normal hours?
Yes, she would often stay late. We would call each other and talk to each other at the end of shifts, and she was always over her shift times because she would spend so much time in her patients' rooms that she didn't get the time to sit at the computer where others, may get in, do a task, get out, get to where they can do their charting. She would take so much time to explain things and take so much time to do the right thing that she did not get to do her charting until later in her shift most times.
We know how that goes.
Do you have any specific recollections of that instances that struck you as being unusual?
Yes, there was one patient that was involved in a MVC and sustained a head trauma. She was 16 and she was set to go to a rehab facility. She's been in the neuro ICU for an unknown amount of time that I'm not aware of, but I know it had been a few days, and in the dynamic, changing atmosphere such as an ICU setting, you don't often have times to do the little things like take out the particles of debris from the trauma that occurred or wipe blood and things like that. And she told me about how this girl being 16, she wanted her to feel good. She wanted her to have the best start that she could going to this rehab facility. And so she took the time to get the remainder of the particles of trauma, the glass, things like that, out of her hair. She wiped the blood. She washed her hair and braided it for her. In true RaDonda fashion, she said, look good, feel good. That she wanted her to feel good, even though she was in this compromised neurological state, to be able to have the best fresh start she could in a rehab facility.
And I don't want to get too personal with you, but did you have a difficult pregnancy and some health issues in 2021?
Yes, so I was admitted to the hospital with some emergency complications when I was 8 months pregnant with my daughter. And I was in the hospital for 10 days. We knew that I was going to stay there until delivery. It had happened in the middle of the night, so I kind of came as I was, didn't have anything.
Deep breaths, RaDonda.
I was let RaDonda know, and the way that RaDonda works is that she is thorough and she's your person that you want there. And all it took was one phone call, and she showed up with 2 giant bags of every, coloring books, a fire stick, shampoo, personal care essentials, pajamas. She brought my family food. We have a picture of her actually plucking my eyebrows and painting my nails in the hospital. And this is in the middle of when she is having her life crisis and when this is going on. And she said, we're not talking about that. We're here to care about you. And that's what RaDonda does. She cares. She cares.
As a friend and a colleague, did RaDonda talk to you about the Charlene Murphy incident at Vanderbilt University Medical Center?
She did. She called me the same day that it happened. Again, we would speak to each other, usually daily on our commutes. And that day she called me.
I'm going to check. That's an offering. Anything. Okay. I'm just.
Judges, the sentencing hearing, I think the rules of evidence are somewhat relaxed on this.
Other questions?
Let me ask you this way. She told you about what happened.
Yes.
And what did you discern regarding the effect that all of this was having on RaDonda?
Essentially, she spoke as though, the best way that I know to phrase it is, this is someone that had experienced a trauma, someone that was in a trauma response. She was slow to speak. She was questioning how this happened. She was very tearful. She was concerned for both Ms. Murphy as well as what is to come as far as her job and, where this would go. I reassured her at that point and told her about a medical error that I made, a medication error that I made, and the outcome of that, and how it was a large error and
Because we all make mistakes.
a positive impact and a change of culture in the facility, and reassured her that these things happen and that she did all the right things and she did everything she could, and we would get through this.
And I think you've been a nurse for about 10 years at this point?
7. Oh, no, just kidding. Graduated 2014, so yeah.
Getting close to that.
Yeah.
In your experience, are medication errors pretty common among nurses?
Yes, absolutely. I have had many medication errors, one of which was very large, and I'm just lucky that the patient outcome was a positive one. I know several people. I don't know anyone who has said to me, I've never made a medication error.
Do all nurses report their medication errors?
You're supposed to.
No. Nurses are advised to report their medication errors. I mean, we know that it is the right thing to do. We are told, that is how you change a culture, that is how you improve processes, and that is what the culture is. However, it's terrifying whenever you make a mistake like that and you have people's lives in your hands and things. You instantly have that flight or fight response, and you think, oh my gosh, what do I do? And of course, our job as nurses is to care for people, and so we check on the patients and then we report. But I'm sure that there's many nurses that do not do that, especially if there's fear of retribution.
That was my question.
You said that you had a very large medication error. Did that result in a patient death?
It did not.
Why did it not result in a patient death?
I caught it in time, essentially.
How did you catch it?
I went to do the same error twice. I actually had this error. It was with insulin. So insulin is a double check medication. You have to have it checked by another nurse. I actually had it checked by 2 nurses because something seemed off. Both nurses gave me the go-ahead. And so I administered the medication. It was based on what the patient ate. So the patient ate more, and I went to redraw more insulin to give him, at which point I realized I was drawing it incorrectly.
How were you drawing it incorrectly?
I was drawing it in a TB syringe and not an insulin syringe.
Okay. So,
Which changed I gave the patient 10 times the amount of insulin they were supposed to have.
and that's something I'm very familiar with. I've been a diabetic for 30 years.
Yeah.
12 years old when I was diagnosed, I had insulin pump there.
Yeah.
So, were you going to get the patient fast acting or slow acting or long acting?
I believe it was fast acting. I was in the ER, so sliding scale is not something that we do primarily. It was a situation that I'm not super familiar with, but.
But how did you realize there was some medication?
I looked down at the syringe and saw that it said TB written across it, where the first time I had missed it because I was distracted.
And you said very kindly, I think that Ms. Vaught was a better nurse than you could ever be. Would you ever commit a federal and state crime just to get done by lying on a federal firearm?
I wanted to check.
I don't have, am I allowed to not comment on that?
Oh.
Can you repeat the question?
Would you?
Yeah.
Would you prepare yourself for this law?
Yeah.
Would you lie on a federal firearm holding your gun, which qualifies as a state and federal?
Not knowingly.
That's all I have.
Call, have one more witness, and then Ms. Vaught will have Julie Schaefer.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
Have her spell her name and I'll prop it up here.
Good morning, Ms. Schaefer.
Good morning.
If you would spell your last name for the court.
Schaeffer.
And you are a nurse, is that correct?
I am.
And how long have you been a nurse?
September of 1997.
And do you know RaDonda Vaught?
I do.
And please tell Judge Smith how you came to know RaDonda.
We met in February of 2019 when she came into my department as a new employee.
And how long did she work in your department?
She left in December of 2019 to go into a separate division.
And over the course of knowing RaDonda, did you all become friends?
We did.
And could you describe the type of person that you find RaDonda Vaught to be?
Yeah, she, she walked into our office not knowing, really what the job that she was going to do entailed. And we weren't sure because we hadn't met her before. And what we found was that she was a very quick learner. She was a great addition to our team. She was always willing and open to learn new things with a really cheerful attitude. In the middle of what had to have been a scary circumstance because it was a brand new type of job that she'd never done before.
Did there come a point in time that you and RaDonda talked about the medication error that she made while she was employed?
Yeah, we never really talked great deals of specifics, but we talked a lot in generalizations about what had happened, yes.
And did you form any judgment about the effect that the entire incident had on RaDonda?
Oh, I know that it was very devastating for her. She always expressed regret in regretful tones in whenever we were discussing what had happened. I know that the burden of what she had done weighed very heavily on her.
And I think, if my math is correct, you've been a nurse about 25 years at this point.
I have the gray hairs to show that.
Do you have any
Don't we all?
thoughts about RaDonda's conduct immediately after she realized that she had made that medication error?
I know that she was very open and she was very transparent about what happened. No one had to come and ask her, what happened with your patient. She was the first person to say what she did. I think in an instant like that, it shows a great strength of character to be able to say, this is a mistake that I made and I did this immediately upon it occurring, which is, I just thought that was an important aspect of her character to know.
And I assume that's not a universal response of all nurses immediately.
I've never, I hate to say it's not universal. Nobody has ever come up to me and said, well, I did this and I didn't tell somebody immediately. But I do know as a human nature, when you make a large error, that it's not always the first thing you want to do is take responsibility for it. I think it's probably easier to talk about it in human nature terms.
That makes sense.
We've been talking about a request that we're going to make with Judge Smith about probation. And you've been in the courtroom this morning. Do you also agree that RaDonda Vaught is the kind of person that could abide by the conditions of probation?
I don't have any concerns that she wouldn't be able to.
Thank
you.
Thank you.
Thank you, Corn Pop. I'll love to watch Nurse Liz too. I'll have to go check her out, see what she's doing. Remember, if anybody has a comment, just drop it up here and I'll pop it up on the screen for you. So RaDonda is going to read a statement now.
I'm sorry that you haven't heard it from me sooner. I'm sorry that I haven't said it to you sooner. I'm so sorry for what you have lost and for what actions have cost you. Your mother, your wife, your grandmother, she did not deserve that. And I'm sorry that this very public outpouring of support for me has been something that has caused you all to continue to live this over and over. You don't deserve that. And I'm sorry. I hope that it has not come across as people forgetting about your loved one. When nurses are upset, they're upset because they want people to take care of people. And I think we're just in the middle of systems that don't understand one another. But no one has forgotten about your loved one. No one has forgotten about his birthday. And we are all horribly, horribly sorry for what happened. No one more than me, but I'm sorry that you haven't heard that from me before. And I want you to know that I will never, ever forget my role in this. And it's just, I don't know what else to say that is going to make anything any different. Saying I'm sorry doesn't seem like enough, but you deserve to hear that, and you deserve to know that I am very sorry for what happened. I wrote a statement, Judge Smith. Words alone will never fully express the remorse and sorry for my actions and the horrific loss of Charlie Murphy's life.
I wish they'd get their microphone fixed.
I am forever and will be haunted by my role in her untimely passing. Numerous times a day I think about her. I have a picture of my grandmother in my house. Every time I see her, I think about Miss Murphy. Every time I see a Vanderbilt logo in Nashville around town, I think about her. I see a person wearing scrubs, and I think about her. I go to check my mail, and I think about her. People walk up to me on the street and offer hugs and condolences, and my first thought is, they're hugging me, but someone else is gone because of that. She may no longer be here, but she is very much alive in my mind and will be. Every day she reminds me of the consequences of my actions. Helping others is a trait that's always come really naturally to me. It's always brought me a lot of joy and fulfillment in my life. And when I became a nurse, caring really genuinely for my patients and their families was just an integral part of my daily life. When they would express gratitude for how I provided here for them, I would tell them I care for people like I was wife. My grandmother became care of. And on that day, I let her down. I let Shirley Murphy down. I let her family down. I let myself down. I was horrified and completely lost. As I said, there's a book on how you proceed. No one's going to tell you what to do after this, or how to feel, or how to express yourself. So, in my profession, you are trusted to be honest and
that was the only thing that I knew to do, was to just maintain my composure in what has been a really horrible situation and try to do the only thing that I have been educated and trained to do in this aspect, which is to tell the truth. At her bedside, because there is bedside to her providers, to my charge nurse, to the educator who is present, to risk management, to my manager, to the associate nursing officer, to the Veritas report that I filled out there that day.
That's an incident report.
Detail as I could about what happened. 8 months later, I was interviewed by the Department of Health, and I spoke with Henry Randolph and provided her with about a 2-hour account of what happened. I never did this again. I had another phone call with the agent from the Department of Health, providing her with answers to what happened. And then I spoke with another agent. And in December, with Ramona Smith at the TBI, in her office there at the Medicaid fraud division, and I have tried to just maintain a professional composure because I don't know what I'm supposed to do otherwise. So if my statements or lack of what appears to be emotion on the outside came across as unremorseful, I can only say that that was terribly inaccurate. In my life, I have learned to hold things in and deal with it. You keep your composure together until you are able to deal with that separately. And that transferred over into nursing and healthcare. You can't be the person to stand at someone's bedside in the middle of something really awful and chaotic happening and fall apart. You have to learn that you put your emotions and your shame and your remorse aside and you deal with it. You don't put that on other people. You don't bring it into that situation. You deal with it at a later time. And the people that spoke to you today, I think that they expressed that I have dealt with those things privately. I try my best not to bring those things into a professional description of what happened here. I just want to make that very clear. After the last interview with Ms. Smith, and I was indicted on charges, I did obtain an attorney, and then again, even with Mr. Science's advice, I continued to tell the truth and express every detail, both in retrospect of what happened, so that the information could be used in the best way possible to make changes, to make people aware of what happened and understand and evaluate these processes in healthcare systems so that things like this don't have to happen again. It shouldn't have happened for something. It did, and we're here now. But hopefully my openness and honestness about my mistakes can help someone to evaluate how to change things for the future of healthcare.
That's what we all hope.
From the very moment that I administered this incorrect medication, I made every attempt to acknowledge responsibility for my actions. I've lost far more than just my nursing license and career.
I will never be the same. When Miss Murphy died, a part of me died with her. And sadly, it was too late to change her outcome when I realized my mistake. But as a nurse, I didn't think of no other way to honor and respect her than to disclose every detail that led to her harrowing death in an effort to ensure that this might never happen to another patient. And I have replayed our mistakes over and over again. I have certainly fallen from grace. I have experienced anxiety, depression, remorse, sleepless nights. This has been the most horrifying experience of my life, and at the same time, the most humbling experience of my life. It is not an easy task for me to stand here in front of you and in front of this person's family, knowing the death that she suffered, and knowing the 4.5 years that they have suffered since this, and ask for your leniency. At the same time, I can't see any public benefit in a harsh sentence. I have no way of ever recommitting benefits like this. I cannot have a nursing license, and I will never be able to practice in patient care again. I will never be able to reoffend. And not a threat to public safety. I am concerned for the people in healthcare and anyone who might, any patient, any person who might become a patient in the healthcare system. That this sentencing is bound to have an effect on how they proceed. Both in reporting medical errors, medication errors, raising concerns if they see something that they feel is needs to be brought to someone's attention, and could potentially have a negative effect on them. And I worry that it's gonna have a deep impact on patient safety. And that comes from the point of any nurse, any doctor, anyone who takes care of patients. The last thing that you want to do is cause them any harm. And we want to make sure that we do things in a way that protects them. It's a very difficult situation to try to express how I feel and how this affects healthcare, and also what is appropriate in the justice system. They operate very differently. I'm just very sorry. I'm really sorry for what happened. Please consider consideration. I'm going to ask you to consider.
God, that's our proof.
Any rebuttal to this mistake?
No rebuttal.
Argument on sentence, mistake.
So I think both sides are done
Your Honor, first and foremost, the court's responsibility is to determine the length.
with the witnesses.
First of all, the state would like to point out that we do believe there is an enhancement factor that applies to this factual scenario. And that enhancement factor would be the defendant abused a position of public or private trust. And quoting from the opinion of State v. Kissinger, 922 Southwest 2B 482, 1996. Factor 15 allows a sentence to be enhanced when the defendant abuses a position of public or private trust. As such, application of this factor requires a finding first that the defendant occupied a position of trust, either public or private. The determination of the existence of a position of trust does not depend on the length or formality of the relationship, but upon the nature of the relationship. Thus, the court should look to see whether the offender formally or informally stood in a relationship to the victim that promoted confidence, reliability, or faith. Your Honor, I submit to you, the victim in this case, Charlie Murphy, was a patient at Vanderbilt Medical Center. When RaDonda Vaught, the defendant in this case, was asked to administer this medication, she became part of this patient. She therefore began a relationship with this patient, a practitioner-patient relationship.
Not a practitioner.
About the application of that enhancement factor, General. The language of the factor that the defendant abused a position of public or private trust suggests to me that there is some sort of intentional or deliberate mental state that would be required for that factor to apply. Are there any cases in which this factor has been applied where the mental state of the offense is more criminally negligent or something, where there's been a mistake of this nature? Obviously, we don't have cases just like this.
Right, Your Honor, and specifically, I think in this, and I'll go down a little bit further, and let me just finish this portion of it. The evidence supports that finding, that there was a relationship, and that relationship promoted confidence, reliability, and faith. I don't think there's any question as to this patient-practitioner relationship based upon the victim, and she relied upon a practitioner, a nurse, to give her the best care. Then it says that if the evidence supports that finding, then the court must determine whether the position occupied was abused by the commission of the offense. And possibly this particular enhancement factor may apply more to the gross neglect of the patient, where.
So can you believe it is applicable to count one?
More specifically, Your Honor makes a good point on that, but the application of that intent would be the knowing standard. And she made a knowing choice to walk away from the patient, knowing that she had to provide that care and monitor that patient. And so I think based upon the analysis by this court, the court must determine whether that position occupied was abused by commission of the offense. And I think it's very clear that when she made that knowing choice not to stay with that patient and not to monitor that patient, that she abused her position.
Is in Kissinger?
Yes, Your Honor.
I'm going to have to look that one up. It's
That particular language is on page 8 of the opinion. Your Honor, I'd like to jump over. I know Mr. Stryans submitted a sentencing memorandum to the court, and having one day, we submitted a brief response to that memorandum. But I think what is very important to note, Mr. Stryans talks about the ability of the defendant to receive 40-35-313 judicial diversion. And specifically within the 40-35-313 statute, now The conviction in this case, as it pertains to count one, impaired adult abuse or gross neglect of an impaired adult, 71(6), 117, and 119 were applicable back in that time. And that would have been under the welfare code. Specifically, you're looking at 4035-313, the effective date is July 1 of 2017 to July 30th of 2018. As used in this subsection, a qualified defendant means a defendant who, jumping down to subsection C, is not seeking deferral of further proceedings for a sexual offense, a violation of 3915-502, which is exploitation of the vulnerable elder adult, 716117, which would be abuse or neglect, or 716119, gross neglect, as this was the conviction of the charge that the defendant was found guilty of. This particular conviction is precluded from any deferral under 4035-313. Furthermore, looking at the statute effective from July 1st, 2017 to December 31st of 2018, specific knowing abuse, neglect, or exploitation, TCA 716117, it also encompasses 716119, which would be the higher charge of gross neglect. Following a conviction for a violation of this section, or section 716119, as was the verdict in this case, the clerk of the court shall notify the Department of Health of the conviction by sending a copy of the judgment in the manner set forth in TCA 6811-1003 for inclusion pursuant to Title 68, Chapter 11, Part 10. Upon receipt of the judgment of conviction, the department shall place the person or persons convicted on the registry of persons who have abused, neglected, or misappropriated the property of a vulnerable adult. So, meaning, upon conviction for 716119, the defendant automatically is permanently placed on the Tennessee Adult Abuse Registry. In addition to any other punishment that may be imposed for a violation of this section, if it's determined by the court the victim was 60 years of age or older, then the court shall impose a fine in an amount between $50 and $200. The additional fine shall be paid to the clerk of court imposing the sentence, who shall transfer it to the state treasurer, who shall credit the fine to the general fund. So, Your Honor, those are conditions that are placed upon the defendant's sentence specific to a conviction for 716119, also precluding her from obtaining 4035-313 as to count one. Furthermore, Your Honor, technically the defendant could be eligible for 4035-313 judicial diversion as it pertains to count two, criminally negligent homicide. I'm reading from an unreported case, State versus Profit, that also cites a reported case, State versus Cutshaw, 967 Southwest 2B 332. In determining whether the court should grant judicial diversion, the court could also take into the same factors as pretrial diversion, and it goes through a list. Several I think are very important to this case. The court should consider the defendant's criminal record, social history, mental and physical condition, attitude, behavior since arrest, emotional stability, past employment, home environment.
She's pretty salty about that comment. You can tell this is all personal.
And amenability to correction. Talking a little bit about attitude.
See, here we go.
The court heard the recording that was played in the state's proof, a snippet of an interview that was given by Ms. Vaught in this case, where she uses curse language to a reporter about the actions of the district attorney generals in prosecuting this case. And certainly this court is well aware that we have a job, we are assigned to do our job. It's nothing personal, prosecuting a case as in any case in Davidson County. So I think the court should take that into consideration.
The factors that the court considers on judicial diversion set out in State versus Left Plain.
Yes, Your Honor, but these factors are also laid out in more detail here in State versus Cutshaw, and it's mentioned in State versus Profit. This particular case deals with a nurse who committed willful exploitation, neglect, or abuse.
Electroplating doesn't mean attitude.
Your Honor, I think this is a more detailed list. Certainly it says, and I'll read from the top of that, once a defendant is deemed eligible for judicial diversion, the trial court must consider several factors in deciding whether to grant judicial diversion. Due to the similarities between pretrial diversion, which is administered by the District Attorney General, and judicial diversion, courts draw heavily from pretrial diversion law and examine the same factors. And then it does go through those factors as laid
So
out.
she wants her sentence because she got her feelings hurt about the comment. Okay.
Necessarily, even as raised here in this opinion, I think the court can look to other factors, even so, involving the defendant's behavior or attributes to the defendant, especially while she is on bond. In this particular case, behavior since arrest. The defendant picks up a new criminal charge, has engaged in criminal conduct.
I agree with you.
While on bond, specifically providing false information on a federal form, and the court certainly has that form to review prior to making its determination, but it's obvious that the defendant did not provide correct information and therefore was charged.
That is so weak.
Certainly, the defendant's lack of criminal record obviously does play in her favor here, and the general reputation from members of the community who have come and testified for her. And I think the court has a balancing test there, but I think the state's position here would be that the court do take into consideration Ms. Vaught's actions prior to sentencing by this court, her actions in the media, as well as her actions in committing other crimes. I do believe Mr. Jackson would like to give a brief response following Mr. Jackson.
If it's this voice, it's mine. If it's annoying, I'll stop. I apologize.
Address the application of an enhancement factor and the question of diversion, but talk to me a little bit about whether Ms. Vaught is a favorable candidate for probation.
Your Honor, based upon the law, being convicted of a Class C felony, being convicted of a Class E felony, she does pose to be a favorable candidate to probation. Of course, the court obviously takes into a balancing test there, based upon her actions, whether she appreciates the nature of this charge, of this conviction. So the court has a balancing test as well, based upon her conduct, to make that determination. But as far as the law is concerned, with her convictions for Class C and Class E felony, she is a favorable candidate.
So she is statutorily eligible, having been convicted of a Class C and a Class E felony, there being no evidence to the contrary. Does the state see any evidence to the contrary that would make her an unfavorable candidate for probation?
It is. It's my YouTube channel.
The state's position, as Your Honor can see, is we don't believe that. Well, obviously, she's precluded from diversion as to count one. She will not be able to get 135 to 13, but the state's position is that the court needs to weigh very heavily on the defendant's conduct and attitude.
With respect to the diversion of count 2?
Yes, Your Honor.
Okay. Mr. Steins?
Thank you, Your Honor. And I will address the eligibility for diversion a little bit later in the comments that I made to the court. Your Honor, I did file a sentencing memorandum with the court. I wanted just to highlight a few things that I thought were very significant to the court's determination. I thought it was significant that Dr. Roy Neely of the Vanderbilt University Medical Center from the Neuro ICU unit sent an unsolicited letter to the court. I received a copy of it and made it part of the 40 character letters that were filed with my sentencing memorandum. Not anything that I spoke to Dr. Neely about, not anything that I solicited. And I think from the letters that you've seen, by all accounts, RaDonda Vaught was an excellent, compassionate, caring nurse. She was obviously very well respected among the doctors, among her nursing peers. Vanderbilt University Medical Center even trusted her to function as Ms. Kessinger had functioned in the role of a preceptor, training new employees. One thing that I wanted to highlight from Dr. Neely's letter, he found her to be a thoughtful and caring nurse. I'm reading from a passage of his letter. And what was notable to Dr. Neely was the consistent high level of attention he saw her provide to so many of the BUMC patients and their families when they worked together in the Neuro ICU. He found her to be very conscientious, that she cared for patients in a very competent way. And he emphasized that she was not, quote, an average nurse. And he expressed general concerns about penalizing nurses for medication errors and the chilling effect that would have on nurses reporting errors. Some of RaDonda Vaught's nursing colleagues, I think, had some very poignant things to say about RaDonda and her work at Vanderbilt. A nurse by the name of Alexandra Shiro, S-H-E-R-O, for the court reporter, wrote a very extensive letter. And just a few highlights from that. She expressed what an honor it was to work with RaDonda Vaught, how much she had learned from RaDonda Vaught, what a clear leader on the 6th floor RaDonda Vaught was among peers and providers, that she was the type of nurse, if anyone had any questions, concerns on the 6th floor, she was the go-to person. And the theme that you've heard from a lot of the witnesses this morning is the over and above and beyond that RaDonda Vaught would go to spend personal time with her patients. Ms. Shiro also noted what was going on at the hospital on December 26, 2017, the day that this happened. She characterized it as one of the busiest mornings that she had ever experienced. Even though it was the holidays, they were very full, had many ill patients according to Nurse Shiro, many of whom needed imaging, needed to be taken from the 6th floor down to the 1st floor. As you know from the proof in the case, Nurse Vaught was the health hall nurse, and she had an orientee with her that day. So there were a lot of things going on for Nurse Vaught in that role as a health hall nurse on that day. And it was interesting that Nurse Shiro talked about midazolam, talked about Versed, and also talked about vecuronium, and that in her experience, the fact that the vecuronium had to be reconstituted, and she put this in italics in her letter, was not a red flag to her, given the medications that they were constantly being bombarded with and how many medications needed to be reconstituted. And also, she noted what came out of the trial, that Vanderbilt University Medical Center had recently changed their pharmacy dispensing system. So the letters are clear from her peers that she was an excellent nurse, somebody that could be looked to. I also made an argument in the sentencing memorandum that in addition to her extraordinary acceptance of responsibility, that's my characterization, talking to the people, the doctors at Vanderbilt, when they were literally at bedside in Miss Murphy's room back on the 6th floor, figuratively scratching their heads, trying to figure out, well, what's going on with Charlene Murphy. Once RaDonda Vaught was handed that plastic bag that had the wrong medication in it, she walked right into Charlene Murphy's room and told those doctors exactly what the problem was. And what followed, she went to an office and put together a Veritas report. The court may remember that term from the trial. That was supposed to be a confidential report that nurses and providers were to put together, where they report anything that they see at the hospital that they feel is not exactly right. And RaDonda did that. And what followed from that was a series of interviews. And whether it was the Vanderbilt University Medical Center, risk management people, to the Tennessee Department of Health, to the Tennessee Bureau of Investigation, and the court heard that 2-hour interview that was played for the jury. I also talk about good works of RaDonda Vaught in my sentencing memorandum in her community. And those letters attest to the fact that she's an integral part of that community and gives of her time and is always the person in the area that's willing to help out any of her neighbors. I thought that was significant. I also briefed the issue of her work ethic, her family contribution, that I think are also strong mitigating circumstances. And I also briefed for the court why I believe that RaDonda Vaught poses really no risk of recidivism. I realized that she was charged with misdemeanor perjury in the General Sessions Court for Sumner County. I think the timing of it, Your Honor, is interesting, to say the least. The event allegedly occurred in August of 2020. There was no law enforcement attention made to that filling out of the ATF form 4473 until a year later. And it wasn't the local Sumner County Sheriff's Office or the Gallatin Police Department. It was the Tennessee Bureau of Investigation. And of course, the Tennessee Bureau of Investigation is the lead agency in this medication error case. So I think they were motivated to pick up the mantle and go up to Sumner County a year later, create this crime, which had not been sought to be vindicated by anybody, not the ATF, not any local law enforcement. And I think I can report to the court as an officer to the court, of the court, that Sumner County is not going to be prosecuting that case. We were in court on May the 4th, and they've indicated that that case will not be prosecuted. I did want to talk about her eligibility for judicial diversion. And there's sort of a lot of statutory twists that I'm going to try to walk the court through and give the court my understanding of why she is eligible on that impaired elder abuse, the Class C felony. She is indicted under a now repealed statute, Tennessee Code Annotated 71-6-119, impaired elder abuse. It was repealed and replaced with another statutory scheme in 2018. And I know the court is familiar with a statute, 39-11-112, that I think contains the answer to this question. 39-11-112 deals with repealed or amended laws. And the relevant portion of 39-11-112 is this. When a penal statute is repealed by a subsequent legislative act, the offense committed while the statute was in full force and effect shall be prosecuted under the statute in effect at the time of the commission of the offense. And that's exactly what happened in this court in the month of March. But here is the language that I think gives the court the authority to grant judicial diversion as to count one. Again, reading from the pertinent portion of 39-11-112. Except as provided under the provisions of 4035-117, in the event the subsequent act provides for a lesser penalty, any punishment imposed shall be in accordance with the subsequent act. So when you take a look at the current plain text of 4035 through 13, that would be the 2019 replacement, which is found in the 2021 supplement. You sort of need a slide rule to get through this maze, but when you take a look at 4035 through 13 B1C, and this is the 2021 version, the 2021 copy part, is not seeking deferral of further proceedings, and then it gives the laundry list of what you cannot be eligible for judicial diversion for. And significantly, 71-6-119 is not in the 2021 or the post-2019 version of 4035 through 13. It specifically does not mention the old statute that RaDonda Vaught was indicted for by the Davidson County Grand Jury back in 2019. So it would be my insistence based on 3911-112 and a plain reading of the text of 4035 through 13, where the old statute is not mentioned. And there are also some ex post facto concerns as well. But the fact that 71-6-119, the old statute, was excluded from diversion eligibility in 2017 is irrelevant to this court's analysis when you apply 3911-112. And I know of, I think the court is to use, my understanding, the court is to use the current 4035 through 13. And I know of no saving provision that was enacted to, at the time that 71-6-119 was repealed. I know that's a little hard to follow, but when you read 3911-112 with 4035 through 13 and apply that language at the end of 3911-112, where in the event the subsequent act provides for a lesser punishment, a lesser penalty, and that's what we have here. So I believe that she is eligible for judicial diversion using the version that's in effect right now with 4035 through 13.
That's the current 4035 through 313 entirely eliminated from the list of ineligible offenses, vulnerable adult abuse or neglect?
Your Honor, there are replacement statutes that are within B1 4035 313 B1C, but they are not 71-6-119. So I think based on that, she would be eligible for judicial diversion. I would ask the court to seriously consider judicial diversion, and the court is correct. The electroplating factors that you refer to, which are the accused inability to correction, the circumstances of the offense, the accused criminal record. She has no prior criminal record at this point. The accused social history, the accused physical and mental health, the deterrence value to the accused as well as others. Those are the electroplating factors that the court will apply, not the unfortunate comments that she made at a very emotional time right after the conclusion of the trial. I know that the state has brought to the court's attention an aggravating factor.
Let me back up just 1 second. Just trying to- Talking about 71-6, 117, and 119, were those offenses repealed or should they be codified?
Your Honor, I think they were repealed.
They were completely repealed and basically redefined?
That's my understanding. No, the only other comment that I wanted to make is the state has brought to the court's attention what they characterize as an aggravating factor, and that would be the abuse of a position of private trust. It's not mentioned in the pre-sentence report. There's been no filing that identifies it. I think that to have an abuse of trust, there would need to be a higher mens rea than an accident. And I think in terms of how it relates to count one, as she stood there on the first floor in the PET scan area, at that moment in time, she did not know that she had made that medication error. She only became aware of the medication error sometime later when she returned to the sixth floor and her colleague, Yali, handed her that plastic bag and told her, you didn't give her SED, you gave Vecuronium. So both in terms of a lack of fair notice and factually, I don't think that abuse of the position of private trust applies in this case.
I guess I'll endeavor to navigate this diversion issue, which I think explained it pretty well. And the state does disagree with Mr. Strian's interpretation, because the act, as originally charged, was recodified. And the recodified statute 3915-508, which today is gross neglect of a vulnerable adult, is specifically precluded. So at the time in 2017 when this offense occurred, it was specifically precluded under the statute for which Ms. Vaught was indicted. Even as it stands today, she is still statutorily precluded from diversion under the new statute. So the state submits 3911-1112 does not apply because there is no void in the law. There was no lesser penalty. The current law, which was a movement from the health and welfare statutes into the criminal code, just changed sections from the 3915, 3917, and moved them into the criminal code now. Still is a non-divertible B felony. There's no change between the previous, as Ms. Vaught was indicted statute, and this one. So 3911-112 would not apply, and even under today's law, she's still precluded from diversion.
Is the current offense identical to the version that existed at the time of the offense in this case?
I'm not the expert on that, Judge. I would have to look back and compare word for word.
Because if it was simply recodified, it just gets moved into another section, but it's identical. My question is, was it repealed and rewritten, or was it simply recodified from one section of the code to another?
And I do not have that answer today, Judge, but I can make a late filing for the court if you like. But I would still submit that if 3911-112 still requires there to be a lesser penalty, you have to punish under the lesser penalty. There is no lesser penalty. It's the same penalty. If you're going to operate under 3911-112 and try to navigate out of diversion and back through again, it's still the same penalty. It's not convertible and it's a big felony. And I mean, without knowing verbatim, I could read from the indictment and the code as it is in 508.
That's right, I've got
Okay.
to do that.
So that, I'll move on beyond that, Your Honor. The state does submit that this is not a divertible offense. It wasn't in 2017, it still is not today. The legislation was very clear about specifically carving out vulnerable neglect, gross neglect of a vulnerable adult from diversion.
So you're saying, let's just, you're saying that the availability of diversion would not be considered a lesser penalty than under 435-117. That's not what that means. Is that the position?
I don't think it is. I don't read it to be a lesser penalty. It is. It's a deferral of proceedings. It's not the penalty is still there whether it applies or not. It is a function. It's a legislative law.
So a lesser outcome.
It's
a more favorable outcome.
It certainly does, but diversion is a legislative largesse. The legislature decides who gets it, and they specifically said in 2017, and then again after 2018 when it was moved into the criminal code, that vulnerable gross neglect of a vulnerable adult is not diversion. And we're gonna have can I continue on? Finish part of time. But I think I think it tells a lot. We've heard good faithful testimony about Ms. Vaught from her friends and people she's known for a while. But it's very concerning to the state that she did lie on a federal firearms law to get an assault rifle when she was under indictment. It's also very concerning to the state that before the jury even decided her fate, she was saying profanities on the news and accusing me personally, my name came out of her mouth, as a liar. And yet she gave an unsworn allocution today. She chose not to testify at the trial. This is her Fifth Amendment privilege. She didn't want to be subject to cross-examination. Obviously, she didn't want to be subject to cross-examination today as giving an allocution as to why, what lies did the state make in our case in chief or in our closing arguments. But instead, the statement went to the media. She ran out of his courtroom and went right down the hallway to give her version of the facts to the world, because she's enjoyed this media darlingship that she's been granted. She has enjoyed being in front of the cameras. She's enjoyed the attention that this has had. Because otherwise, why was she not coming into this courtroom?
I'm sorry, what?
Everybody was true. But she goes out there and says, I lied, and the state lies, and then we're out to get her, and then we don't, not to quote her, but we don't care about nurses and we don't know about health care.
You would agree that the trial of this case was an emotionally charged week. And at the end of that week, an individual who has been through that might say things that they probably shouldn't.
She talked about her professional composure, keeping herself composed. Her allocution, she made it sound like she can hold her emotions together, but she didn't. And she could have walked out of the courtroom and respected the prosecution, respected the sanctity of this court, respected the sanctity of the judicial process and the criminal justice system, but she didn't. She instead tried to say that everybody's lying against me, and I'm a good person, and I'm sweet little RaDonda Vaught, and I didn't testify because I didn't want to be drawn through the mud, but I really maybe didn't want the jury to know that I lied on federal firearms.
Wow.
Just get this on. Because she's betrayed herself in the media and with the witnesses here today, that she is just as pure as the driven snow. But I don't think that someone that is truly as genuine as she wants the court to believe would just to get a gun, commit a federal offense, and then go out and curse on TV and blame people who are public servants for doing their job.
So that's what this is all about. He's mad about that too. Okay.
And I think she appreciates the seriousness of this offense by engaging in that.
Triumphs that the state of Tennessee has chosen not to pursue that offense, pursue that charge in Sumner County.
Your Honor, courts, different jurisdictions do things for different reasons. His implication was that we somehow stirred the hornet's nest on that and got it going. But Agent Smith certainly testified that the instant check comes through TBI. That's how TBI got involved. And then when it wound up on Ramona Smith's desk, she's like, I investigated this woman for a homicide.
And my question is, do you disagree with Mr. Striants that the state of Tennessee has chosen not to proceed with that charge?
I have not received any word from, I can certainly understand the retirement and the subsequent dismissal after a period of time with a misdemeanor. I can understand that. But it still doesn't, I have not received any verified confirmation, neither has the court, that this has actually been disposed of, but it still does not negate the fact that she engaged in that behavior while she was out on bond. And that is considerably concerning for the state. But Your Honor, I mean, the ultimate question, when does civil medical negligence become criminal? And in this case, it's when it results in a death where a jury decides that she fell below the standard of care and committed so many egregious acts and oversights during that process that somebody died. And we had two members of the healthcare community on the jury who found that. We had an expert witness who testified about the facts of the case and what nurses are supposed to do. You're supposed to check the medicine. Even their own witness said she would have checked the medicine. I think at the end of the day, it's just check the medicine. Their witness talked about the medication error. It was a volume thing, but she grabbed the right medicine. And I won't go any further with that, but we're talking about, she didn't even look at the medicine. There's no proof of that. That is completely egregious in this situation.
What's the state's recommendation on sentence? That you've just made the same argument you made to the jury, and they agreed with you. They agreed with you. So now tell me what does the state wish the court to do on sentence?
The state wishes that the court, whatever sentence the court imposes and whatever words the court uses in pronouncing the sentence must promote respect for the sanctity of life, the sanctity of Charlene Murphy as a patient, the sanctity of her family, and respect for system, this court, the criminal justice system, and the jury's verdict. Whatever that may be is your decision.
I mean, the words that I use are the words that I'm asking you about the sentence. I mean, the sentence is what it is. The length of the sentence, the manner of service, and I understand the state's position on diversion. I understand that position. What's the state's recommendation on the length of sentence and applicability and propriety of an alternative sentence?
We are not seeking, we didn't file an enhancement factor. She does not have a record, so it would be between 3 to 6 years for the C felony and 1 to 2 for the E felony.
You argued an enhancement factor earlier. You're asking the court to enhance the sentence.
Ranging enhancement as in within the range.
Okay.
Enhancement factor would be within.
So you're arguing she's a standard offender.
She is a range 1 standard offender.
Okay.
Not felony.
And you've argued that at least one enhancement factor is applicable.
Yes, Your Honor.
And so do you have a recommendation or a position on the length of sentence as
The
to?
length between 3 to 6 years.
Mhm.
I think whatever the judge finds is fair between 3 to 6 years for this offense.
So you don't have any position about where?
We do not have a position
Okay.
on how long she is either incarcerated
Okay.
or placed on probation.
And you're not seeking consecutive sentencing?
We are not, Your Honor.
Okay. Are you advocating for any service of time in custody?
We're going to leave that entirely up to the court in your discretion and your wisdom.
I mean, I have statutory factors that I have to consider, obviously, but it's always helpful to have, we're in an adversarial proceeding, and I listen to both sides, I listen to arguments, and I weigh those arguments and apply them to the evidence before me. So, but you're saying the state doesn't take a position on probation?
The position that we have is she is non-divertible and the offense needs to go on the registry. Our concern was that she not be able to kill another patient or cause harm to any of the patients in the future. And however that can be accomplished, Your Honor, is all the state is concerned about.
All right.
I'll sit down.
Thank you, General.
Well, she has no license, so that's taken care of.
On the eligibility for judicial conversion, just by the terms of the replacement statutes, I don't think it's just a reconstructed statute because it is a Class B felony in its new iteration. So it's facially not a recodification of what came before. So it would be my insistence that if they wanted to preserve 716119, it should have been mentioned by the legislature in 4035, 313C, B1C, and it's not. And I would ask the court to apply the plain text of the current version of 4035, 313, and find it to be eligible as a criminal.
Thank you, Mr. Triance.
Can I return just very briefly? on
Yes,
this?
ma'am.
So basically, they're arguing right now about diversion, and that means whether or not to suspend the sentence.
I apologize, Your Honor. I had it pulled up and I lost my place. I'm almost there.
Obviously, the prosecution does not want the judgment diverted. They seem very angry about her statements that she made after trial, and this seems personal.
The reason that these offenses were moved was to codify them in the criminal code. The 71 section dealt specifically with welfare. And the District Attorney General's Conference made a big push in 2017, 2018, 2019 to have these laws moved over because of the creation of the Vulnerable Adult Protective Investigative Team and these acts to try and promote stopping abuse, neglect, misappropriation, financial exploitation, sexual abuse of vulnerable and elderly adults. So the big movement came to codify these within the criminal code. I disagree with Mr. Striens. If you look, and this is specific to 4035, 313 now, if you look at the statute for 4035, 313 back at the time of this offense, which was the charge that in the 71s that she was convicted of, it is specific in that statute that it is precluded, it's prohibited, you cannot get diversion there. If you look at 4035-313 now, it is specific as to the same part of the statute, 3915-508, which says offense of aggravated neglect of elderly or vulnerable adults. Talks about the caregiver commits the offense of aggravated neglect of an elderly or vulnerable adult who commits neglect, results in serious physical harm. That is the same language. Now that still keeps it at a Class C felony. The B felony results in serious bodily injury. That's what bumps it up, that classification. But serious physical harm, that's the same type of harm that the state had to prove in order to find her guilty.
I agree with you that it looks the same.
Yes, Your Honor.
It's kind of similar.
Yes, Your Honor.
And maybe the intent is that we're going to take this crime out of this section and we're going to put it in this section. My question is, and my question before was, has the statute been rewritten? Has the offense been redefined in any way? I'm hearing Mr. Stryant say that at least part of it has been elevated in terms of sentencing. So it's not entirely true from what, unless you disagree, that it was just picked up and moved from one section to another. It was literally repealed and rewritten. So am I allowed to sit here in this proceeding and see if I can figure out what the intent of the legislature was? I can't do that, can I? I have to look at the statute.
Yes, Your Honor, but I think it speaks volumes to the fact that there was a reason that these charges, these crimes were moved to the criminal code.
But I can't consider that. I have to look at the statute.
Yes, Your Honor, but I think what is important as to that, if Mr. Strines is saying we need to look as to the intent of 4035-313 as it relates to this time period, as Mr. Jackson said, this particular offense, gross neglect, aggravated neglect, neglect that causes serious physical harm of an elder or of a vulnerable adult, is still precluded even today from obtaining 4035-313. That is the intent of the legislature here, Your Honor, because that type of crime hasn't changed. It's just been moved over to the criminal code and recodified.
But there has to be more than it being just that type of crime. It's more than that. It has to be because this offense, 716119, does not exist anymore.
It does not, Your Honor.
So 716119 no longer appears in 4035-313. So what gives me the authority to ignore the plain language of 4035-313 and to include a crime that does not exist anymore in the list of crimes for which diversion is no longer an option?
Well, Your Honor, she was prosecuted under the 716119. That was the intent of the legislature. Let's move back in time. Had she been prosecuted under that time when this specific crime was listed in 4035-313, obviously the legislation has changed. It's been updated to reflect the new laws, the new language that's been codified under the criminal code. But I think what's specific is that the court has to look to what is the intent of the legislature here. The intent of the legislature.
Tell me why. My question is, tell me how I can consider that. Tell me how I can look beyond the language of 4035-313 that's applicable today. And if anyone else has any, I'm happy to hear from anyone from the state on this, because I don't know. I'm hearing about, and I understand that the legislature does things and makes decisions and rewrites statutes all the time. Maybe it was an oversight. If it was an oversight, I can't call it an oversight. I've got to look at the language of the statute.
Your Honor, do you have a copy of the 4035 that was effective from July the 1st, 2017 to June the 30th of 2018? If I may.
I do.
Just make sure that we're comparing apples and apples.
You're saying the copy that was effective.
At that time specifically.
Okay, hang on.
They're spending so much time on this because this really is the crux of the case, whether or not this
4035-313
can be diverted.
effective until January 1, 2020. Is that what you're? Is that what you have here?
2017.
Okay. And it includes 716119, I see that. And the statute, the section that is applicable until 2020
Yes, sir.
also includes 716117.
Yes, sir.
Okay.
And just to let the court know.
I mean, I understand that at one point it was included,
Yes, Your
but
Honor.
my question is, now it's not included. So,
Specifically, the welfare code section 716119, is not included. But because it has been converted over to the criminal code, and just to let the court know, if you look in the code now, if you look at 4035-313, it's still the language, it talks about a qualified defendant. But if you look to section C, Your Honor, the place where 3915-502, which was financial exploitation, that is the same code section that is listed under the 2017-2018 for financial exploitation because it had already been transferred over into the criminal code. Exactly where 71.6, 117, and 119 is listed in that statute now places 3915-508 and 3915-511. And 3915-508 is the aggravated neglect of an adult. So I think there's a problem here with the way it's written. I certainly agree with the court here, but
I mean, I can't correct that, can I?
no, Your Honor. But I think looking at the intent here of what the legislature did by recodifying into the criminal code, putting the exact same.
She's saying the same things over and over and over again. It's getting kind of annoying.
Within that subsection in 4035-313, because the law has just been modified or updated to be in the criminal code. I don't know that the legislature would have added 71.6.117 or 71.6.119 just for the simple fact that that's not the code section in the criminal courts or the criminal laws that we proceed under anymore.
It is if you committed your offense when that was the statute in effect.
Yes, Your Honor.
As we did here.
Yes, Your Honor, but I think the court can take consideration of the fact that it was enumerated in 4035-313 at the time, and that's the time that she committed the offense, and that should be the laws that she is held under as her sentencing. But I think the legislature would not have put in this particular statute in the 2021-2022 books, just because that's not under, we don't act under the welfare law anymore. It's specific to the criminal code. So I don't think you can just negate the fact that the statute has changed without looking at the language and the meaning of what's behind this. The intent of the legislature here is you cannot abuse an elder or vulnerable adult. You cannot neglect an elder or a vulnerable adult. You cannot financially exploit. If you do, you are not eligible for 4035.
So just to be clear, your argument as to the reason that 3911-112 that deals with repealed or amended laws, the reason that would not provide relief in this instance with respect to diversion is because the offense is similar and the legislative intent was that it just be moved to a different section.
That is exactly what happened, Your Honor, and that was the big push by the District Attorney General's Conference to codify these offenses within the criminal code, and the court can see that based upon the 3915-502, which is within the 4035-313 statute that had already been moved over at the time in 2017. Financial exploitation was the first crime to be moved over.
Hang in there, Rhonda.
All right, I'm going to take a recess. I'm going to review the evidence that's been presented, review my notes from the trial, review the case law and the legal arguments that have been presented, and then we'll come back and announce a decision. That decision would probably, I'm going to estimate that it's going to be probably 1 o'clock before that happens. So if you want to plan to be back here by then I'll have a decision.
All rise. Court's in recess.
Okay, well, you just heard the judge. It looks like they're coming back at 1 o'clock, which is 2 o'clock Eastern. So I will pick this back up in the stream again. That whole business at the end with the, I'm going to turn the stream off, but that whole business at the end with the making sure that the diversion was happening or not happening and why it was codified differently. All of that is because what is really in question here is whether or not, or what they're talking about at the end here is whether or not she can have basically a suspended sentence. And that's what they're talking about. So it makes a big difference. That's why they spent a lot of time on it. But the judge, I could tell, was getting a little irritated at the end because counsel just kept saying the same thing over and over and over again. And she kept saying, so you want me to discern intent of the legislature? Like, that's not how this works. We have something written down and we have to look at it. I think a lot of things came out of this hearing this morning. After we do the live stream this afternoon, when the verdict is announced, I'm going to do a wrap-up session this evening. So make sure you come back for the live stream when the verdict is announced and again later. But until then, have a good day. Talk to you a little bit.